Yes.
May it please your lordships.
Hmm.
Well, I beg to mention item number 20, my lord.
20.
20, my lord. WPC 5305.
Yeah.
But because of subsequent development, my lord, this writ petition has become infructuous. My lord.
Mr.
R. Dubey.
R. Dubey. Item 20.
20, my lord.
Your name is not there.
I know item 36.
Oh, sorry. I'm sorry. Sir. Item
20
36.
is the code number. 37 is.
36.
36, my lord. 5305.
Okay.
May I please your lordship? I am for the respondent.
Oh,
36.
respondent.
Yes.
Mr. R. Dubey, the counsel for the petition submits that the writ petition has become infructuous.
S. Yasmin on behalf of M. Sharma.
And my lord, I am for respondent number 3 and 4,
Hmm.
annexing standing counsel for IRCTC.
1, 2 for bank and 3,
Yes,
4
lordship.
Yes,
IRCTC.
is this recorded?
1, 2, 4 bank and 3 and 4 for IRCTC.
Yes.
And annexing standing counsel for IRCTC.
Are present. In view of the above, writ petition is dismissed as infructuous.
Well,
Yes.
Much obliged. Lord.
Yeah, please, Lordship. Lordship, I beg to mention item number 17, my lord.
17.
Lordship.
Hmm.
We had got some personal difficulty today, my lord. Matter is after
On the prayer of Mr.
A. Mubarak.
A. Mubarak, non-counsel for the petition, list this matter after 4 weeks.
May it please the lordship. May it please the lordship. Lordship, I beg to mention item number 15 of today's list, lordship.
15.
15.
Yes.
In this matter, I have to file a rejoinder, my lord. I have not been able to establish contact with my client,
Mr. S.
Vishwakarma.
On the prayer
May
of
it please your
Mr.
lordship.
S. Vishwakarma.
My lord, in this matter, I am appearing on behalf of senior counsel Mr. P.K. Tiwari, who appears for respondent number 7.
Learned counsel for the petitioner. Correspondence is granted
4 weeks, lordship.
4 weeks time to file affidavit in reply. Mr.
U. Pathak, on behalf of senior counsel Mr. P.K. Tiwari, counsel for respondent 7.
If you are learned counsel for the respondent has no objection. No. Is present. List after 4 weeks.
Obliged.
may I please your lordship.
Yes.
My lord, with the consent of the other side, I beg to mention item number 14, my lord.
14.
This matter may kindly be listed after last week of January or first week of February.
Your name?
P. Colita.
Mr. P. Kalita. No, on the prayer, Mr. P. Kalita, and counsel for the petition. List this matter after 4 weeks.
My lord, I wish to mention item number 59 of supplementary list, my lord, with the concern of the, my lord, the other side, my lord. My lord, in this case, 59, my lord. In this case, my lord, the orders matter, my lord. In this case, my lord, the respondent, my lord, file, my lord, the additional affidavit, my lord, on my lord 7th, my lord. I have received, my lord, through mail, my lord. My lord, some time may be given, my file, my lord, the reply, my lord. So next week, my lord, any date, my lord.
59.
Lordship.
Which for the applicant?
My lord, the applicant, my lord, is already, my lord, gave consent, my lord. Through mail, my lord, I have received, my lord, the additional affidavit, my lord.
Additional affidavit?
Yes, my lord. They file, my lord.
IA
Yeah.
filed by whom?
I have filed by the respondent ONGC, my lord. I am the repetitioner, my lord.
Okay.
So, my lord, as per the direction of the Honorable Court, my lord, 2811, my lord. They filed, my lord, on 7, my lord, additional affidavit. So, my lord,
Have taken consent
yes, lordship. So, my lord, next week, any date, my lord.
on the consent of
I'll reply, ma'am.
learned counsel for the.
Alan Dihingham, my lord.
No. Mr. L.N. Dhingia, learned counsel for the petitioner. Petitioner oblique? No. Learned counsel for the petitioner submits that he has recently received a copy of the additional affidavit filed by the respondents,
Lordship. On 7, my lord.
to which he would like to file necessary affidavit. Therefore, he prays that matter will be listed after 10 days.
No, my lord, next week, any date, my lord.
After a week. Praise the Lord. List matter after a week.
My lord, there is an interim order, my lord, interim order.
Interim order passed earlier.
Obliged.
Lordship, item number 23, my lord. I am appearing on behalf of N. Rahman, my lord. He has some personal difficulties. The matter may be adjourned for 1 week.
On the prayer of Mr.
J. Lashkar, my lord.
J. Laskar, Learned Counsel, appearing on behalf of Mr. N. Rahman,
My lord.
Learned Counsel for the list this matter after 4 weeks.
Lordship, the interim order may be considered.
Interim order passed earlier. Continue.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 43 of today's daily list, Lordship.
43.
Yes, Lordship.
Yes.
With the consent of the other side, Lordship. Lordship, I beg for 2 weeks, Lordship.
For what?
Sir, Lordship, we have received the instruction. We'll be shortly filing the affidavit, Lordship.
You are for?
Industries and Commerce Department.
You are for respondent.
Yes, Lordship.
Mr.
N. Kalita.
N. Kalita.
On behalf of
Counsel,
A. Kalita, Lordship.
appearing on behalf of
A. Kalita.
Mr. A. Kalita, Learned Standing Council Industries and Commerce, submits that an instruction has been received on behalf of the respondent, for which he required some more time to file the affidavit. Therefore, it was the matter may be adjourned up for
2 weeks, Lordship.
2 weeks.
Always.
This to matter after 2 weeks, so as to enable the Standing Council for Industries and Commerce to file the affidavit.
Obliged.
May I please, Your Lordship? I beg to mention item number 4.
Yes.
In this matter, my lord, it is a long pending case, my lord. We have to take instruction from our client about the survival of the impugned order. That's why 4 weeks time may be granted for taking instruction.
Why?
About the survival of the impugned order, my lord, we have to take instruction from
All
our,
of your the client right now. We'll see.
we have tried in the morning, my lord, unable to contact the phone number. Maybe
What is the matter?
matter is the petitioner is a small tea grower, my lord. Small tea grower. Then they have the plots of land, and the government has taken a policy decision, but an impugned order was passed for eviction for the petitioner's land, my lord, which is going against the decision of the government, my lord.
Have you been evicted?
Not yet. Government not yet filed.
4 weeks, not 4 weeks. 1
2
week
weeks.
we can grant
Not-
to obtain instruction.
Government not yet filed their affidavit also, my lord.
Yes, which for the government.
Yes,
What is the issue? I mean, what is the status?
Malad, I'll take instruction. Malad, maybe 2 weeks.
2016 matter.
Lordship,
It's
I
an
understand. I
eviction
have seen
matter.
the record, Malad. Yes, maybe please after 2 weeks, Malad. By the time I also get instruction.
Although the matter is pending since 2016,
Lordship.
no response has been filed. Mr. Both the Land Council for the petitioner, MS Pivora, and Ms. MS,
You does additional.
you thus Land State Council for the respondents. Expressed that the impugned order may have lose its may have
There is a
the
stay
impugned
order.
orders.
There is a stay order.
Impugned order might have not been survived by now.
Malad, that is not my prayer, Malad. My prayer is I'll take instruction. This is hard prayer.
No, anyway, the submits that the impugned order may have lost its force, therefore, press for a week's time to obtain instruction. List of listed method after a week, so as to enable the parties to obtain instruction. After a week,
Malad. But regarding losing of the Malad, strength, Malad, that is not my.
Then
That
see,
is hard.
then
That may be
see-
harm out because
he says he submits a
Malad,
fever
petitioner
that had lost its force. Therefore, she prays for a week's time to obtain instruction. Mr. MS so-and-so, London State Council also prays that since she has not received instruction, she also prays for a week's time to obtain instruction.
Malad.
In prayers alone, so-and-so.
Obliged.
May it please your lordship, I beg to mention item number 37. Lordship, with the consent from the respondents, matter may be kindly be taken up after revocation on the first week of January.
What is the matter?
Lordship, I have been instructed by my senior Mr. Amit Goel to mention the matter due to the personal difficulty.
On the prayer of Mr. So-and-so, Land Council appearing on behalf of Mr. A. Goel, Land Council for petition, list this matter after 4 weeks.
Much obliged.
May it please your lordship. Lordship, item 38, my lord, I beg to take it up after vacation, my lord. 38. Item 38, my lord.
On the prayer of Mr. M.R. Khandakar, learned counsel for the prayer, list this matter after 6 weeks.
After 4 weeks.
After 4 weeks.
I beg to mention item number 8, my lord. This matter may kindly be adjourned today because senior
Item
counsel.
8.
Yes, ma'am. For
2019 matter.
18, ma'am.
What is the matter?
My lord, it's an order challenging the order of recovery officer of debt recovery tribunal and judgment and order.
On the prayer of M.S.
And Ahmed.
and Amin.
And Ahmed.
Ahmed. For your name is not there.
Oh, my lord, there's been by mistake, my lord.
You were for petitioner.
Yes, ma'am.
Item 8.
Yes, ma'am.
Why your name is not there?
My lord, while filing, there was a mistake, my lord.
What mistake? Have you
My-
filed the power?
No, my lord.
Then
Huh?
are you appearing for petitioner?
No, my lord. I'm appearing on behalf of the senior counsel, my lord.
Who?
Mr. M.K. Chaudhary.
Then say that no. I'm a so learned counsel appearing on behalf of Mr.
And
M.K. Chaudhary, learned counsel for the petitioners. Press that matter may be listed after 4 weeks as her senior has some personal difficulties today. Mr. Praise allowed. List this matter after 4 weeks.
May I please, Your Lordship? My Lord, I beg to mention item number 46. My Lord,
56.
46. As per the instruction of the petitioner, my Lord, I pray for not praise this case, my Lord.
Mr.
M. Islam.
M. Islam, learned counsel for the petitioner, submits that the writ petition has become infructuous. Mr. Accordingly, the writ petition is then dismissed as infructuous.
Highly obliged, Your Lordship.
Please, Lordship. Lordship, I beg to mention item number 56 of supplementary list.
56.
Yes, Lordship. In this matter, Lordship, we have received their reply on last week, Lordship. We need to some our response, Lordship.
You are?
I am for the petitioner, Lordship.
Mr.
M.M. Zaman, Lordship.
Mr. M.N. Zaman, learned counsel for the petitioner, praised for and granted 4 weeks time to file affidavit in reply.
Lordship. Deeply appreciated.
May I please, the Lordship. Lordship, item number 13. The engaged advocate, Lordship, is having some personal difficulties.
1-3.
1-3, Lordship.
Yes.
So, Lordship, engaged advocate D. Bormon, Lordship, he is having some personal difficulties. So, matter may be adjourned, Lordship.
What is the matter?
Lordship, I am not here, Lordship. His mother's illness, so due to his mother's illness, he is not positioned to come before this.
Give the second copy. You read and make a mention.
So, Lordship, already informed me, Lordship, that consent has been taken, Lordship. Other side.
You read the second file.
I'll-
May I please, Your Lordship? Lordship, I beg to mention item number 47.
Yes.
Learned counsel of the petitioner, Mr. S.H. Jaman, could not come to the court due to some medical emergencies, Lordship.
On the ground of Mr. S.H. Jaman, learned counsel for the petition having some medical problems, Mr. So-and-so, learned counsel.
S. Alam. S. Alam.
Yes, Alam, learned counsel. Press for adjournment of the matter for 3 weeks. Mr. Praise the Lord, Mr. Abdul for 3 weeks.
Obligement. May I please, Lordship?
Yes.
For the counsel of other side, Lordship, I beg to mention item 39, Lordship. Lordship, senior counsel Dipu Chalia will appear in this case, Lordship. Senior counsel Dipu Chalia will appear in this case, Lordship.
Yes.
Matter may be adjourned for 2 days, 2 weeks, Lordship. He has some personal problem.
On the ground that Mr. P.P. Chalia,
D.P. Chalia.
D.P. Chalia, senior counsel
Senior counsel.
for the petitioner has some personal difficulties today. Mr. So-and-so,
Emran.
learned counsel for the petitioner. Emrana.
Emrana.
Learned counsel for the petitioner. Press for listing of the matter after 4 weeks. That's where the list after 4 weeks.
May please your lordship. Lordship, I beg to mention item number 12, my lord. My lord, my senior is now out of station for undergoing medical treatment, my lord. Matter may be fixed after 2 weeks, my lord.
2019 matter.
Yes, my lord.
Are you running the market?
Yes, my lord.
Still running the market?
Yes, my lord.
What for?
My lord,
Market for what?
my lord, no idea for that for this matter, my lord. So
If you don't have any idea, we'll pick up the matter. Don't make a mention. Give the second file. Take the second file and read and come.
May I please, your lordship? Lordship, I beg to mention item number 34 and 35, lordship.
34 and 35.
Matter
Yes.
With the consent of the other side, lordship, I mention this matter, lordship.
Sir, what is the matter?
Matter, lordship, the petitioners are the legal heir of the refugee who came from, lordship, East Pakistan, lordship, and the
Yes.
government of Assam, by notification, lordship, established a colony and allotted land to the father of the petitioners, lordship. And subsequently, lordship, the fixation of price, lordship, it was enhanced, lordship. Lordship, that's the matter, lordship. And lordship, petitioner's father already paid the
Are you a citizen of India?
lordship.
How?
Lordship, by birth, lordship.
You said you have come from East Pakistan.
Lordship, that was the refugee, lordship. The petitioner's father, lordship.
Ah.
And subsequently, the land was allotted in the name of the father of the
How
petitioner.
the refugee can be allotted the land?
Lordship, government of Assam by notification, lordship, established a colony, lordship.
For allotment of land to the refugee?
Lordship. For
Is it a settlement area?
lordship.
So what do you want?
Lordship, kindly matter may be taken after 2 weeks, lordship.
Why?
Lordship, my senior Mr. M.H. Ahmed have some personal
On
problem.
the ground of Mr. M.H. Ahmed, Learned Counsel for the petition has some personal difficulties today. Mr.
I mean, lordship.
I mean, Learned Counsel for the Learned Counsel submits the matter may be adjourned adjourned to 2 weeks.
Lordship.
Mr. Prayer allowed this after 2 weeks.
Hello.
My lord, sorry, my lord, item number 59, my lord, my senior pen, my lord, come, my lord, date may be fixed, my lord.
Lordship has adjourned this matter for him to file an additional affidavit. There is some.
He said he has taken the consent.
My lord, I wanted a please date
my lord.
because this I is for
59.
vacating the
59.
59.
Yes.
Can your lordship fix it on 18th? 18th.
18 December.
My-
December.
Yes, my lord.
May I speak, Lordship?
Yes.
Lordship, I beg to mention item number 13 of today list, my lord. Actually, my lord, item number 13 of today list, my lord. Actually, the engaged counsel's mother was not, her condition was not good, so that he is unable to present today, my lord. So I'm praying the date matter may fix some other day, my lord. The engaged counsel D. Burman, his mother was not, his mother condition was not good, my lord. So he is unable to present today in the court, my lord. So I'm praying that matter will be fix some other day, my lord.
Your name?
G. Bhaskar, Vinod Bhaskar on behalf of D. Burman, my lord.
Who was the counsel who had appeared earlier, who had asked
Yes,
for the adjournment?
Yes, my lord.
Isn't it clear?
Earlier, item 13,
Yes,
was the other counsel?
Lordship, I am extremely sorry, Lordship. I have another matter, so that's why I've come.
So,
Lordship, petitioner's Lordship, he has informed me, Lordship, the engaged advocate D. Burman, that he is having some personal difficulties.
what is the matter?
that I had no idea, my lord.
If you don't have idea, don't make a mention. We are not granting. You take the file, second file and read and make a mention. Either of the two, give the second file. I think it should be given to him. He looks more, he looks junior than you.
Not,
Who is junior? Who is senior?
he is senior, my lord.
Therefore, you take the file and read and make a mention.
Bibliography.
Yes.
May it please your lordship,
Kindly last chance may be granted, Lordship, to take steps upon
With
respondent
cost,
number.
with cost. On the prayer of Mr. M.S.
J. Ghosh.
J. Ghosh, learned counsel for the petitioner. J or D?
J.
J. Ghosh, learned counsel for the petitioner. Further, 2 days time is granted to take steps for service of notice upon the respondents in terms of the order dated 18/04/2022 as a last chance. In case no steps is taken, in case no steps are taken by the learned council as granted herein above, within 3 days as granted herein above, appropriate and necessary orders shall be passed on the list next day. List the matter after 4 weeks.
Oblige, Lordship.
May I plead your lordship?
Yes.
I have for impediment of party lordship.
Yes.
The respondent was
Who is the
National Highways Infrastructure Development
any
Corporation.
objection? No.
No.
Heard Mr.
M. Hussain on behalf of IRL.
Learned counsel appearing on behalf of the applicants. You are petitioner.
Lordship.
Petitioner also. Applicant petitioners. Applicant's petitioner. And also heard Mr. C.K. Sharma Barua.
C. Barua. C. Barua.
C. Barua. C. Barua. Learned counsel for the respondents. Next para. This is an application praying for implement of the National Highways and Infrastructure Development Corporation Limited within bracket NHIDCA in short, as party respondent in the connected writ petition being WPC 293 of 2020. Next one. Having considered the submissions of land council for the parties and also the perusal of the statements made in the application, I'm of the view that the prospective respondents, i.e. NSIDCA, appears to be a necessary party in the connected with proceedings in view of the nature of the grievance raised by the petition applicants or the petitioners. That the learned counsel for the respondents in the interest of for better education, appropriate education of the grievance raised in the said petition, writ petition, has no objection for such improvement of the prospective respondent, i.e. NIDCA. Next one. In view of the above, the National Highway and Infrastructure Development Corporation, represented by the General Manager, bracket close, Assam, Guwahati, is permitted to be included as party respondent number 4 in the connected with petition. So and so. Next page. Is respondent number 4, the application things
Read.
allowed in this quarter. Is allowed in this quarter. Huh? In the Writ Commission, in view of the order passed to insert, the land constituted petitioners to file the amendment post that step thereafter. They need to register to do the need to.
My lord, another IA was filed long back, it was 578, 2021.
Yes.
Striking of National Highway Authority at Lordship last order, this NSADC first to come, get implemented, then after, because this already been, this roading question is being constructed by National Highway Authority, which is now recently implemented as a response number 4. NSA is wrongly implemented, that is why I have filed IA 570/2021. Now that can be disposed of. Because last occasion it was not disposed of. Let first NSADC comes and get implemented. Thereafter.
Where is the IA?
IA 578.
It's not listed today.
It's
not listed today.
Oh.
We'll take it up some other time. If it be listed.
Yes. If file is not there, wait.
You will have to file the amendment within 2 days, huh? 2 days. Close.
Always, Lord.
May I please, Your Lordship? My lord, the matter relates to the compensation, land compensation, my lord.
Yes.
What happened, my lord? Land was acquired in the year 1997, my lord, and my lord, possession thereof was taken to my lord way back, my lord. But the payment was made in the year 2015, my lord, and hence we made a prayer, my lord, for enhanced amount.
Have you filed
that is, my lord. Now, my lord, this case is covered by the Indoor Development Authority.
Therefore,
I have made ready,
have
my
you
lord.
brought-
Today I am filing, my lord. I have made it ready. So, my lord, let the matter come after vacation, my lord. In the new year, my lord. Voluminous
Mr.
AFNU Mullah.
NU Mullah, counsel for the petitioner, submits that he would be filing the required affidavit to bring on record certain pleadings in view of the pleading as allowed by this court on 18/11/2024. Allowed by this court by the order dated 18/11/2024 during the course of the day. Mr. Therefore, the press that matter may be listed after 4 weeks. Who is appearing?
My lord.
MSU Das
For one.
and Mr. A. Bhattacharjee, learned counsel for the respondents are present.
7, 8, 9, 10.
Are present, huh? And are present and have raised no objection. Mr. Accordingly, let this matter be listed after 4 weeks.
Obliged.
Yes. A. Bhattacharjee.
Lordship, may kindly grant me some 10 days time, I'll get the instruction.
Why?
It
was granted on 14/11.
Yes, I'm yet to get the instruction.
Mr. A. Bhattacharjee, learned Standing Counsel for the Revenue Department, press for further 10 days time to obtain instruction As regards the present status of the proposal in respect of the allotment of land to the petitioners, as allowed by this court on 14/11/2022. In 22,
Yes.
you have been granted 4 weeks time.
Yes, yes.
Now after 2 years,
Let me pursue this another way.
considering the next nature of the grievance raised in the Learned Council, Mr. A. Bhattacharya is granted further 10 days time to obtain instruction and advise this court as directed by this court on 14/11/2022 as a last chance in view of the fact that the matter is pending since 2017. Mr. S. Gattolani, Senior Counsel, assisted by
As that,
as that
For respondent number 4.
respondent 4 is present.
Obliged.
Then we just say right on top, Mr. Burma, non appears for the petition on court. Huh?
Obliged. My lord, in this, I prayed for 2 weeks time, my lord, to file my reply against the affidavit, my lord.
When? Affidavit is filed when?
My lord,
2017 matter.
My lord, it was received only on, my lord, on 11/6, my lord.
What is the status?
My lord,
You have been evicted.
yes, my lord, I have.
Then
My lord,
nothing remains.
my lord, no, my lord, in the last order, my lord, your lordship had ordered that to, my lord, in view of the endorsement made by the counsel of the petitioner, let's Mrs. S. Sharma, learned government advocate for the state respondent, obtain instruction or file affidavit on behalf of the respondent 3 addressing especially the issue of the status of the settlement, my lord, of subject land in favor of the petitioner, my lord.
Yes.
That is already pending, my lord.
So what is the instruction? You have filed the affidavit.
My lord, and yes, we have filed the affidavit on, my lord, in the year
That was
21, my
earlier-
lord.
earlier affidavit, my lord.
21, my lord, we have filed.
No, on 12 June 2024, you were directed to file obtain the instruction.
My lord,
Have you seen the order 12/6/2024?
my lord, my lord, my lord, my colleague sent a letter, my lord, but we have not received. My colleague sent a letter on 13/6/24. My lord, may I pray for, my lord, one chance to obtain the instruction, my lord.
And meanwhile, I will file my reply, my lord.
Want to reply,
On the MS Udas
my lord.
and the State Council submits that although the instruction
এইটো ডেটত আছিলে ন জুন মাহত
from the respondent as directed by this court on 12/6/2024 has been communicated. However, she has not received any instruction. Therefore, she prays for further 2 weeks
2
time.
weeks, ma'am.
2 weeks time to obtain the instruction. Prayer for praise the Lord. The London State Council is granted further 2 weeks time to obtain instruction as set for, as prayed for, as a last chance. Last chance, 2017 matter.
I'll try my best, ma'am.
In the meantime, Land Council for the petitioner may file their affidavit in reply, if so advised.
Public.
7.
Your Lordship, the Forest Department has filed their affidavit, Your Lordship, and we have to file a reply against the affidavit in opposition.
2018 matter.
18 matter, Your Lordship. There was a delay in submitting the survey report, Your Lordship.
When they filed the affidavit?
We have received on 1911.
1911 of
Yes,
this year.
Lordship. This year.
On Miss MS.
N. Mahanta.
N. Mahanta, learned counsel for the petitioner, submits that since the respondent authorities, particularly Forest Department.
Forest
Department has filed their affidavit, which was received on
1911, 2024.
2024. She pressed for further. She pressed for 3 weeks time to file affidavit in the court. Considering that, although the matter is pending since 2018, considering that the respondent has filed their affidavit in the month of November 2024, the prayer for adjournment, a prayer for a time to file affidavit in reply is granted. List the matter after 3 weeks.
Deeply obliged.
My lord, in this case, my lord, today we'll be sending a letter to the petitioner as regards the status, present status of the case, my lord.
What is the matter?
Because this matter relates to demarcation as to whether there is any demarcation or not. I pray, my lord, this matter will be taken after the vacation. In the meantime, we will seek the instructions as regards the present status. Today we'll be sending a letter to the petitioner.
Mr. S.
Khaun, my lord.
Khaun, then counsel for the petitioner, submits that he would be sending a letter to the petitioner for instruction.
For instruction.
Letter during the course of the day, as the matter relates to, as the grievance relates for a direction to demarcate the land. Demarcate the land or what?
Of the petitioner, yes, my lord.
Demarcate the land of the petitioner. Therefore, he prays that letter will be listed after 3 weeks.
Much better.
Praise the Lord, list the matter after 3 weeks.
May I please, Lordship?
Yes.
In this case, Lordship, I am appearing for respondent number 1, 3, 4, and 5. But we are yet to receive the extra copy, Lordship.
Extra copy is not been served to us.
Extra, we are yet to serve with the extra copy.
I think last okay. The matter is pending since 2019.
Yes, yes.
You are not responding just because no extra copies has been given.
When on 25.
And last occasion,
Yes.
this court has indicated all the learned counsel for the
19.
all the learned counsel for parties not to take an excuse of not furnishing extra copies. I have suggested if you have a difficulty, you are for the respondents.
Not for the all respondents. Some of the.
For the state.
Yes, yes.
For the state.
Yes.
If you are really, if the state is really a poor, not being able to have Xerox copy of the petition, will help you. Come to the registry or come to our chamber. We'll get it Xerox and give it to you. Do you have the one copy you have?
Only one.
Don't make an excuse. Anyway, you furnish. On the prayer of Mr.
S.R. Burua.
S.R. Borua, learned State Council, and Mr.
R.S. Ronghang for respondent number 6.
Learned Council of 6. List this matter after 3 weeks so as to enable them to file affidavit in opposition. And Council of petitioner to furnish the extra copies. We're not recording it, but then don't make a mention. Don't take that excuse. Next time. Just because you have not been furnished with the extra copies, don't make an excuse.
Lordship, interview may be continued.
It's between you. I mean, it's your colleague.
No, actually, Lordship, this is the normal practice, Lordship.
Normal practice,
Yes.
but then when I'm not concerned. I mean, when I'm not encouraging that. You can ask it why should wait for, and equally you have to fund it.
Lordship, interim may be continued, Lordship.
That's the whole problem. What is the matter? Eviction.
Lordship, eviction matter, Lordship.
Interim order passed earlier, second.
Did you advise, Lordship?
See, interim order is in favor of the petitioner. Your action is being challenged, put to challenge. 2019. Just because you are not getting extra copy. You have the copy. At least one copy you have.
Yes, yes.
Just making an excuse.
Advise, Lordship.
Also, perhaps they have received the amount.
This is listed for the second time after 2019.
Lordship.
What is the amount?
They are claiming 8,20,000. But so far as from our instruction, it goes to show that they are entitled for a total amount of rupees 7,92,290.
Yes.
And it was sanctioned in the year 2019 itself, Lordship. So perhaps they have received the money.
None appears for the petitioner on call. Mr. No, this application has been filed, praying for a direction to the responding authorities for payment of outstanding bill amount of total rupees 8,20,000. Due to the petitioner for hiring of his both BOH. Next para. Mr.
S.R. Borua.
S.R. Borua, Learned State Council, by placing the instruction, a communication that is 23/12/2019. Where is it?
Asia Inspector General of Police.
Where it is?
Lordship, the para was
Para 8.
In para.
Submits that the petitioner is entitled to an amount of rupees 7,25,132, which has been sanctioned for payment of petitioner to the Superintendent of Police, Barpeta, against the higher charge bills submitted by petitioner.
One more amount is there, Lordship, 33 something. Altogether, it will come around 7,92,290.
Para 10 is what? The petitioner submitted the higher charge bills for the, but all the bills. This stuff. And amount of rupees?
One amount is 7,25,000 something, and another one amount for the period 1/1/2016, the 33,000 something, Lordship.
33, where it is?
It is there in the last page, Lordship.
Two amounts.
Two amounts. First one is 7 lakh something, Lordship. Second one is that 33,579 for another period.
Total is?
Total it will come around 7 lakhs 92,290.
And another bill amount of rupees 33,579. The sanction which has been already granted on 13/06/2019. No, 13/06/2019 and 30/09/2019.
And for the period, Lordship, 1/1/2014 to 31/5/2015, 14, he has not submitted any bill. It is reflected in our first page of our instruction.
Anyway. Since the petitioner, next, having considered that the claim of the petitioner is of a total amount of rupees 8,20,000, and the amount admitted comes to the total of rupees
7 lakhs 92,000
7 lakhs 92,000
290 rupees.
290 rupees, which is as nearly as claimed by the petitioner. And considering that none represented the petitioner, which indicates that the petitioner might have already received the payment, as the respondents had already admitted the amount as noted here. The requisition is disposed of. It is provided that the requisition is closed. It is provided that it is provided that the respondent authorities are expected to release the amount, admitted amount by them, as indicated above, if not already paid to the petitioner.
That communication may be kept as a part of this record.
The copy of the instruction placed by the learned counsel, Mr. S.R. Bora.
S.R. Borua.
Borua. He kept on record and marked this X.
Applies.
Yes. Market is for what? Market is for what?
Market is Lordship, cattle market, Lordship.
Cattle market, beef has been banned in the state.
Lordship,
It's banned in the state.
beef is another matter, Lordship. Cattle market is another Lordship.
Cattle for what?
Cattle for Lordship.
It's not for consumption.
Buffalo and for agricultural purpose, Lordship. For sale and purchase for agriculture.
So what is your prayer?
Lordship, my
How you are agreed?
Lordship, the circle officer write letter dated 8/12/2016, Lordship. Annexed 4, Lordship. They sent a notice to ask Lordship to stop the cattle market, Lordship, as per Supreme Court guideline, Lordship.
Yes.
But as per the Supreme Court guideline, my Lordship, kindly look into page number.
Page?
Lordship. Page number 37, Lordship.
37. Annexer?
Annexure 7, Lordship. There are no such order, Lordship, by the Honorable Apex Court, Lordship. from 31 onwards, Lordship. Relevant page is 37, Lordship. In this case, there are no such order, Lordship. There are no such order, Lordship. The circle officer mentioning the order of apex code, Lordship, but there are no such order to stop the cattle market, Lordship.
That's the only reason.
Lordship. The circle officer arbitrarily
stop the market.
Lordship.
Where is the interim order? Where is the interim order?
Lordship, page number 20, Lordship. Translated copy, Lordship, 20, Lordship. You are hereby informed that as per the order dated 5/11/2015 passed by the Honorable Supreme Court of India, as per direction issued by State Level Coordination Committee on 15/11/2016, functioning of cattle market has been banned within 20 kilometers of Indo-Bangladesh international border. The order dated 5/11/2015, Lordship, by Honorable Apex Court, Lordship, but there are no such order, Lordship.
No, Supreme Court may not
Lordship.
directed to ban the market,
Lordship.
but then certain issues are there.
Lordship.
In view of that, this
Lordship, all people
order
are
has been issued.
Lordship.
It's not necessary to, stop or ban the market.
Lordship, it is a village area, Lordship, rural area, Lordship, and all
Yes. Anybody?
all people are from farmer
Lordship,
community.
kindly
Lordship.
come to page 22, Lordship.
Yes.
There is some order of the district magistrate. It refers to some state level coordination committee meeting, Lordship.
Where is that Supreme Court's order?
Lordship, let them fight affidavit, Lordship.
Because from this order,
They have annexed the Supreme Court order.
as per the Supreme Court, as well as some refers some state level coordination.
Sir, why you are
committee.
not filing an affidavit?
Lordship.
See, sir, these are appears to be very small matter, but then it's equally sensitive.
Yes, because
There is a ramification also.
because Lordship,
You cannot take it lightly. You file an affidavit
Lordship.
immediately. Heard, Mr.
Ahmed Sheikh, Lordship.
Learned Counsel for the petitioner. Mr. S.R. Borwa, Learned State Counsel, representing the respondents, is granted 4 weeks time to file affidavit in opposition. As the method relates to banning of cattle market within the 20 kilometers of Indo-Bangladesh international border in terms of the order of the Supreme Court. Dated 05/11/2015 and as per the direction issued by the State Level Coordination Committee on 15/11/2016. This is the matter after 4 weeks. You file it, find out.
Lordship.
State level, Lordship.
Yes, sir.
Actually, my lord, in this case, my lord, response number 4 along with the response number 5 to 10, my lord, illegally constructed a godown in my plot of land, my lord. When I came to know, my lord, I filed a complaint before the GMDA, and GMDA, my lord, visited the site visited the site, my lord, but it was not clear, my lord, what structure has been constructed, my lord. That is the matter, my lord, and in the last occasion, my lord, also I was directed to implement the
33 number Azara.
33 numbers of Azara. So my lord, I'm saying that my 33 number of Azara Gram Panchayat.
The Lordship, as per order dated 13/11/2024, petitioner is supposed to take steps
Yes, my lord.
for implement of 32 number Azara Gaon Panchayat.
Yes, my lord.
At the same time, GMD is required to file the affidavit on taking proper instructions. And for
Yet you have
respondent
not
of
done
form.
anything.
Yes, my lord.
And for respondent of form.
That you have not done.
I will take a step, my lord.
In time. That time, now. It is sometime before.
It is
Yes, my lord,
informed
sometime
by
we granted, my
Mr.
lord. Sometime we granted to file a implement application.
It is informed by Mr.
P. Passport, my lord.
Huh?
P. Passport on behalf
Learned Counsel, appearing on behalf of Mr. D. Burman,
Yes, my lord.
learned petitioner in person,
Petitioner person.
that Mr. D. Burman has some personal difficulties due to ailment of his mother.
Yes, my lord.
Mr. Next paragraph. No, please. Therefore, we press that matter may be listed after 4 weeks. Mr. It is noticed that this court, noticing the conflicting reports by the respondents, has allowed the petitioner in person to file an appropriate application to implement the 33 number Azara Gaon Panchayat. However, no such application has been filed as on date. Next paragraph. Considering the submission that the learned counsel, considering that Mr. D. Burman, the petitioner in person, has some difficulties due to ailment of his mother, further 3 weeks' time is granted to take appropriate, to take necessary steps as directed by this court, as allowed by this court on 13/11/2024. This is the matter of.
That's it.
Deeply obliged, my lord.
Yes.
Hello, this pertains to a night shelter home. The petitioner was running a night shelter home, my lord. And this night shelter home was as a designated camp during COVID-19 for the sick and
Forget about, have you filed an implementing petition? Application.
Implement application.
It is no longer under the social welfare department.
It is under the urban development. my lord.
Therefore, you have prayed for time to file an application for implement.
No, my lord, implement petition has not been
11/08/2023.
No, my lord, implement petition has not been filed, my lord. And moreover, the petitioner
Mr.
has.
Huh?
And the petitioner has also surrendered the night shelter home. Anyways, my lord, I'll bring.
If it surrender, will it has become infraction?
No, surrendered, but by dues remains, my lord, I'll impute them, my lord, because they have already utilized my service, my lord. They cannot, they are state. They has to act responsibly, my lord.
No, whatever is to be done, you have to do it, Mr. Biswas.
Yes, yes, yes. We'll,
If
we'll
you
get,
are not interested, if you have surrendered, are you challenging the removal?
so, my lord, my limited grievance here is that you have utilized my service during the pandemic time, and then you were shifting the goalpost one from this department to that department. My lord, we will impede him. My lord, I can understand, my lord, since the new department has come.
It's not me. It's you. On your prayer only this was granted.
But yes,
What do
because-
you want by this petition?
Pardon, my lord?
What do you want?
My lord, I want a release of the fund pertaining to 2019 during that COVID period, my lord. My lord, may kindly come to the prayer of the petitioner at page number 11.
First prayer you are not pressing.
First prayer, my lord.
Impugn order is what? 05/11/2019. Director.
But we'll get this urban development into picture. My lord, we'll impede him.
See, your prayer, number one, you are challenging the 05/11/2019.
Absolutely, my lord.
Where it says it will be within the, it will be by the, under the urban, what is called?
But as on
Urban Development, Government of Assam.
But
Will
as-
be adopted by urban development.
As on-
There would not be any fund for 2019 and 2020. And you are claiming the fund, release of fund for 2019 and 20 and 2020. What is this?
My lord, the issue is this, my lord. Now, as on date, my lord, whether it is run by the urban department or any department, we are not concerned. We have surrendered. But, my lord, during the COVID time, my lord, they have utilized my service, and they have not paid it. The allocation was there. Now, where the money, the Supreme Court has directed.
Where it is?
My lord, will kindly come to the direction passed by the Honorable Supreme Court. Page number 32.
See, the Social Wealth Department has decided, the government has decided that that will be under the Urban Development Department, right? And it clearly says that there would not be any fund for 2019-2020 by the, under the Social Welfare Department. So can you interfere that, no, it should be under the Social Welfare Department?
No, my lord, to that extent, it is the prerogative of the government.
Then why are you challenging this?
No, my lord, but that no fund business, my lord, because that is affecting me.
No fund, it's by the director, I mean, by the Social Welfare Department. It's their prerogative. If fund is not there, how can he create?
My lord will kindly come to, because they are saying that the fund is not there.
And ultimately, you are also admitting that it will be under the urban development.
Yes, as of now, it is under the urban development. So therefore, my lord,
First of all, the impugn orders you are trying to challenge. I mean, we don't find anything. And in that impugn order, it says there would not be any fund for 2019 and 20. You are claiming the release of fund of 2019 and 20.
But they have utilized my service, my lord. They utilized my service.
When this order was passed in 2019, that there would not be any fund under the Social Welfare Department. And it will be taken by, adopted by the Urban Development Department. And Urban Development Department is not before this court.
Therefore, my lord, I will impede, because recently, the last time also, we made a prayer for
Every
it.
day, why you are making that mention? Is it,
I understand, my lord.
these courts, these orders are just to be on the paper.
I understand, my lord, because my lord, can it be after some time, my lord, I'll take a specific instruction, probably whether my client is interested to at all press for this matter or not. any
Yes,
further.
I think it's better. Unnecessary.
Yes, unnecessary, because they are also not showing interest and we are facing.
You take an instruction after some time.
In 18, there is a judgment of this coordinate bench of this honorable court,
Yes.
whereby the claim has been rejected.
Yes.
On the ground that when there is a road accident, a person dies, if the vehicle is identifiable, then he can seek compensation under MVA. So he cannot claim double benefit of ex gratia and as well as this one.
This for ex gratia.
Yes. So that is being decided already. That I have copy. I have already given to 270023. I am told that the money has been sanctioned already. He has got the instruction. Money
Sanction.
sanction. Sanction.
For payment of
Payment already released. Released.
It was transferred to the act of
release.
Really. So matter has become infractuous in view of this.
So, having this judgment also, you are paying it.
$21,823. Saturday. Same. Let him get it off of name.
And then they are claiming 2 lakhs.
2 lakhs.
You have sanctioned 4 lakhs.
4 lakhs clear?
Huh?
For perhaps 2 persons. 2 cases.
No. 4th June 2020. Niju Sanwal.
Ah, yes, Niju Sanwal.
4 lakhs.
2 lakhs fill 11.
How many petitioners are here? Look at this.
They mentioned it twice.
No, no. Just look there, that marked portion.
4 lakhs.
4 lakhs.
Yes.
মানুষ দুটা মৰিছিলে। Knock the petitioner's father and daughter. 2 persons died. 2 persons died.
But claim is here, it's 2 lakhs. 2 lakhs only. Entitlement is 2 lakhs, right? Where is
Yes,
the scheme? Where is the policy? Not appears for the petitioner on call. Huh? Next para.
The policy is page 22.
22.
Serial number 3, it is 2 lakh.
Serial number 3. Ex gratia to NOK. A person killed due to accident in public places or in the public areas other than killed by The claim is under this tree, serial number 3. In the present case, the claim is under serial number 3.
Yes, yes.
Yes. By filing this application, the petitioner
Third type. So third type will be done.
has prayed for grant of rupees 2 lakhs to the petitioner on account of the death of who died? Who is the
Father died.
Father.
Huh?
Father of the petition.
On account of the death of her father due to
Amol.
what accident?
Yes.
Motor accident.
Motor accident.
In terms of the policy of the state by notification dated 15/11/2014, whereby it provides that whereby inter alia it provides that whereby it provides inter alia that ex gratia to the next of the kins of person killed due to accident in public places or in public areas within bracket other than killed by extremist oblique terrorist oblique miscreants and due to firing of security forces bracket close. Mr. Next para. Where is that instruction?
Leading. Lordship.
Mr. A. Bhattacharya, State Council, as well as Mr. S.R. No.
S.R. Borua.
S.R. Borua. A. Bhattacharya and Mr. S.R. Borua, learned council, learned state councils, by placing the instruction submits that the petitioner has already been paid the ex gratia amounting to rupees 4 lakhs for 2 persons, right?
Yes, yes. 2 persons died.
But claim here is for only 1 person.
In this case, claim is made for 1 person, but from the record.
Record shows 2 persons died.
For 2 persons amounting to rupees 4 lakhs, which has been transferred, already transferred in the account number of we are concerned about what?
Mr. Amol. Amol is also died and the later one also died, daughter.
Okay. Others they have not filed anything. They have not filed the petition. Account number being account number in the Federal Bank being 200-201-000-15696 on 04/06/2022.
Lordship may keep the instruction or file of the record.
Having considered the submissions and on perusal of the instruction as placed by the state councils, the matters appears to be in process as the petitioner has already received the amount as spread for. on 03/06/2024. In view of the above, the requisition is closed as infructuous.
Obliged.
The copy of the instruction, communication, instead of instruction, you said communication, huh? Dated 11/07/2022 is kept on record and marked as X, document X. You, account number, if you have any confusion, it's here, huh? In the instruction.
My lord, I don't want to press it. My lord, we will withdraw it. Withdraw that. Item 16 will withdraw.
Withdrawing.
Withdraw. Just give us a liberty. If they at all want to file it, including some new respondent, they may file
Mr.
it.
Item 16. M. Bishwas, learned consular petitioner, on instruction submits that the petitioner would not like to press the present writ petition. Accordingly, the writ petition is closed on withdrawal, closed as not pressed. Then we said you liberty, with a liberty to file fresh list of. Accordingly, writ petition is dismissed on withdrawal. So dismissed as not pressed with a liberty as.
I'm deblessed. I said to do I said sanction was it? So already money has been sanctioned.
My lord, here, my lord, husband of the petitioner died in the accident, my lord.
It has been paid.
It goes to show that our instruction, it was sanctioned way back in 2021.
Yes.
Sanctioning.
This is a sanction order, my lord. Whether fund is released or not.
When did you file this writ petition?
Writ petition was filed, my lord, in the year 2021, 10/8/2021.
And this sanction order is of 15 November 2021.
15 November 2021.
Then
And maybe released, my lord, but this in instruction not.
you have no instruction.
Yes, my lord.
We'll close it. We'll say that if not released, release it. It's
Yes.
already sanctioned.
Yes, my lord.
Yes.
Heard, Mr.
M. Hussain, my lord.
Learned counsel for the petitioner. By filing this application, the petitioner being next of the kin has prayed for a direction to pay an amount of rupees 2 lakhs as ex gratia done to the petitioner on account of the death of late Mayaz Ali. Who is Mayaz Ali?
Husband of the petitioner.
Late husband of the petitioner in terms of the notification. In terms of the government policy being office memorandum dated 15/11/2014.
Yes.
Same.
Yes. Yes.
Where it is?
Yes,
It's same policy.
Same notice.
Yes,
Yes, sir.
15.
Just write same search. That sub policy. Page 15.
Yes, 15, my lord. Serial number 3.
That's same, you right? Which provides so and so, huh? Internal so and so. Mr. Same. Both the Learned State Council. By placing the communication dated 15/11/2021. Submits that an amount of rupees 2 lakhs has already been sanctioned for payment of ex gratia grant to the petitioner. on account of the death of her husband, late Maya Jani. Mr. They submits the London State Council submits that since by now the petitioner might have received the said amount of ex gratia. Having considered the submissions and on perusal of the sanction order dated 15/11/2021, and considering that the present writ petition was filed on 10/08/2021. It appears that I'm of the considered view that the petitioner might have already received the ex gratia amount as sanction, as the sanction was accorded on 15/11/2021. Although the petitioner, the learned counsel petitioner, has no instruction to that effect. Considering about, I deem it appropriate to close this writ petition with a direction that the amount already sanctioned by order dated 15/11/2021 shall be released to the petitioner, if it is not already been released. This petition states the communication so and so. It is not so and so. Yes.
Petitioner deletion of name from the voter list.
So, will it not
FT,
be
FT councils are there, FT and
will it not be placed before the appropriate bench?
no, matter was placed before the division bench as per the last order.
Yes.
So it is matter pertains to single bench, Lordship. That's why it was referred to appropriate bench. So far as my understanding is concerned.
Where it is?
Last order 17/11/2021. There's division bench order.
It has been submitted in this petition seeking for deletion of his name from the list of doubtful names. It has been submitted since it has been a challenge to any opinion. Yes, what is to be done?
Petitioner is not
Can
there.
we file affidavit? No.
Lordship, actually, standing council active foreigners tribunal matters. There is separate set of councils.
Who has are their name not been reflected?
K.
Gogoi, G. Sharma, L. Devi, B. Devi.
Mr. G. Sharma.
Non-appearance petition on call. List a matter after 4 weeks. In the meantime, the respondents may file their counter. Yes.
Higher Education Council version. I've just I've put a response number 1. Meter has become infractuous also. Meter has become infractuous perhaps.
I think so.
That's why they are not appearing.
It's tender of 12/11/2021.
21. And perhaps no stay was also granted.
Stay was granted, but it was not extended.
Extended.
Ultimately, it was not extended.
Perhaps they participated in the tender after getting the stay order from here.
Huh?
Perhaps they had participated in the tender also after getting the stay order from this honorable court.
Non-appears to the petitioners on call. Petitioner on call.
I'm for response number 1, SR Burwa.
SR Burwa, London District Council appears for response number 1.
1.
No affidavit, nothing.
The Lordship main tender was issued by that respondent 23. They are the main answering respondent also. Higher education.
List the matter after, since no affidavit is there, list the matter after 4 weeks.
May it please your lordship. Lordship, the matter has been withdrawn by the petitioner from us. The brief has been withdrawn from us, lordship. Item number 22.
and we tried to communicate with the petitioners, but we were unable to contact the petitioners since we saw the cause list. So our name will be strike off from the cause list, Lordship. They have taken the brief from us.
Yes, respondent.
NF Railway. What's the NF Railway? NF
Higher citizen.
22 no? 22. We are for the state.
What's to be done?
A time may be given to them. At least we will try to communicate with them that the matter was listed.
They've taken the brief from you.
Lordship.
Mr.
D. Roy.
D. Roy, Land Council submits that the petitioners,
Petitioners, Lordship.
one petitioner.
Lordship.
Huh?
No, Lordship.
Petitioners have withdrawn the brief from him. However, he submits that sometime may be granted to him so as to obtain instruction to inform the petitioner regarding the listing of the matter. It is noticed that on the last occasion, none has represented the petitioner when the matter was listed. Next one, considering the submissions of Land Council, let this matter be listed after 4 weeks. On the next day, if petitioners are not represented, appropriate necessary orders shall be passed.
Obliged.
Yes.
Lordship, here also they have withdrawn the brief from us and they have engaged different counsel. Their name is in the cause list, Lordship. So kindly our name will be strike off from the cause list, Lordship.
Your name is?
D. Roy on behalf of T.S. Hazarika.
Huh?
D. Roy on behalf of T.S. Hazarika.
What is the name of the new council?
Lordship, S.K. Behra and J. Rajbongshi.
What is the matter?
Matter pertains to railway matter. Challenging the policy.
None appears for the parties. List this matter after 6 weeks. 2023, 6 weeks.
My lord, stem vendor, petitioner stem vendor is accommodate, my lord. Then there is a notice, impugn notice to vacate this space. That is why he approached. Now, my lord, situation is changed, my lord. Previously in Sibsagar district,
Matter has become infructuous.
because previously in Sibsagar, my lord,
Not
district
Mr. So-and-so, Land Council for the petitioner.
not infructuous, my lord. In that sense, that it was shifted and a new accommodation was given. Because of the pendency, the petitioner could not be gone. So it may be closed with the direction that he may apply for new place, my lord. This district administration is
No, your grievance is your cancellation.
not cancellation, my lord. Notice is given, my lord, page E, page 23, annexure E, my lord.
For what? Saying what?
See, they say that that place creates some problem. So the
So now that has been shifted to other campus.
now
Shifting of
my lord
in
just
view of the shifting of the court campus of district judiciary.
yes, that was
So you apply nothing doing.
yes.
That become in process.
So one online observation may be given.
Nobody is stopping. You are not debarred. You can always apply. Because your notice was in a certain area, campus.
Yes.
Now the campus has been shifted somewhere else. So
Not
nothing
the
remains.
district. The district is separated. District board.
Yes. It has been
And
shifted.
there is accommodation is given. Now because of pendency, he cannot apply, my lord. So when this disclose it, it is liberty that line. Otherwise, they said you file case against us. He is 33 years. He has
Heard Mr.
MJ Burwa.
Huh?
MJ Burwa.
MJ Burwa, counsel for the petitioner, and Mr.
SR Bora for response number 2 and 3.
Sir Burwa, Mr. Counsel for respondent 2 and 3, and A. Bhattacharya for
Response number 1.
it is submitted at the bar that the no issue is survives to be adjudicated in view of the fact that in view of the shifting of the court campus of district judiciary. Yeah, this stuff.
There is notified place also. Because of pendency, he cannot. So
The district judiciary of Sipsagar. Therefore, the matter has become infructuous. The writ petition stands close as infructuous. Mr. However, the petitioner is at liberty to apply.
yes,
Apply for what?
for stem bending zone, my lord, in the notified area. For
May apply for what? It's a
for carriers, stem
Huh?
bending business, stem bending business.
business.
Vendors.
What is business? What do you call it? Stem bending.
Yes.
May approach the appropriate authority for granting, what do you call it?
My lord, page 22, it says that it is an appointment as a stem vendor. It was a district judiciary appointed. as stem-
22.
Yes. His appointment is a stem vendor.
Where it is? Page
22, my lord. After verification report, so and so, he was appointment. as- Therefore,
the Mr. However, not however, the next paragraph, petitioner is at liberty to approach the appropriate authority for appointment of stem vendor in a new campus.
My lord, his appointment was never being cancelled. He was asked to shift his place on.
Then, my lord, the appropriate decision.
Because in that page 22
In that
itself,
case, become infructuous.
Now,
Tenth clause as infructuous, that's all.
then if they says this is not, so he may approach for new placement. Otherwise, they will give indictments that your case is closed, dismissed, or like this. So that is why one line observation. Otherwise, livelihood will be affected.
Apply for what?
For new place, accommodation in new place, notified place.
You are already a stamp vendor already.
Yes.
You are already a stamp vendor.
he's running
Yes.
his business, Lordship.
Huh?
He's running his
Now,
business.
now, my
So
lord,
he
I
can apply for the
Because
appropriate
that
place.
page 22, Lordship.
news.
Page 22, Lordship, it is very much clear that that he will arrange his own accommodation, sitting accommodation at the Sipsagar Port campus.
That is why they said that
Yes,
that place
that liberty is already granted.
that
in
place
that
is
order.
create disturbance. Now new notified places there, we have to shift there. So one line observation, otherwise they will create troubles.
The petitioner is at liberty to approach the appropriate authority for appropriate place as a stamp vendor.
Yes. Obliged.
Affidavit has been prepared, Your Lordship. Lordship, I need 1 week
What is the
time.
matter?
Non-payment of contractual bill, your lordship.
Yes, what is the amount?
10,88,561.
Heard Mr.
Decision.
Learned Counsel for the petitioner. MS
Ardeka,
Ardeka, Learned Standing Counsel.
Water Resource.
Water Resource Department. Praise for and is granted 3 weeks time to file affidavit. Are you admitting?
Lordship, amount is admitted, your lordship, but we are not the appropriate authority, your lordship. We have released our share, your lordship. I will file, your lordship.
Okay. 3 weeks, make it 3 weeks, huh?
Yes, your lordship. 28, 29, same, your lordship.
28, 29, same order. Same order.
Obliged.
I am appealing for a 5 to 7, lordship.
Yes.
We have really entered appearance because although there is a standing counsel, we are appearing as a standing counsel, but this one was moved without serving a copy to us, lordship. And thereafter, we have recently entered appearance, lordship.
Non-appearance for the petition on call. Mr. So-and-so,
K.
Learned
Kolita.
Counsel. A.
K. Kolita.
K. Kolita, Learned Counsel. Standing Counsel.
I am appearing as a counsel for on behalf of the standing counsel A. Sharma, lordship.
A. Kolita, Learned Counsel appears for Mr. A. Kolita.
A. Sharma.
A. Sharma. Learned Standing Counsel for respondent number
5 to 7, lordship.
5 to 7. This to matter after 4 weeks.
Hello.
So as to enable Mr. The Learned Counsel for the respondents to file their reply, affidavit notice. Yes.
There is a case, my lord, the husband of the petitioner, my lord, died by electrocution, my lord. While he was fishing in the bill, my lord, suddenly the live wire front and fall on her husband and died on the spot, my lord. Accordingly, my lord, the petition
yes,
lost and the
J. Burman, APDCL.
My lord, the electrical inspector already submitted the report, my lord, Annexure 30 on the affidavit filed by the respondent number 6, my lord.
Yes.
And operative part, my lord, base 33.
Running.
Contravention, my lord. Running base, my lord, 33.
Yes.
Contravention. From the facts and circumstances leading to the accident, it appears that there occurred contravention of regulation 12 to 13.1, 13 to 16.1, and 35 of the Central Electricity Authority measures relating to safety and electric supply regulation 2001 on the part of the owner of the overhead line, that is the Assam Power Distribution Company Limited, my lord. Because as per report, it is revealed that, my lord, the accident has occurred for the fault of the APDCL, my lord. So, my lord, the petitioner is entitled the compensation, my lord, in terms of the regulation as well as the notification issued by the Electricity Department, my lord.
Why you have not annexed that?
Because at that time, my lord, it was
should be strictly complied with the owner of the substation and supply line for installing, maintaining the supply.
I have given the notification, my lord, 7/11/2009.
Why you have not annexed it?
Because, my lord, it was not with us at that time. At that time, my lord.
Yes.
As per this notification, my lord.
Representing APDCL, lordship. I am for 1 to 6, 1 and 6, lordship. We have filed our affidavit on behalf of electric inspector, lordship. There is some fall on the part of the APDCL. They are not appearing, lordship.
It's a problem.
My lord, because, my lord, so many times was taken by the APDCL, my lord.
With APDCL.
And last chance was given to file affidavit, my lord. That is why they may not
Will
appear.
take after some time.
My lord.
Inform him with the application.
My lord.
You know him. You know the
I
council.
him, but his contact number not with me, my lord.
I don't know why you're adjourning it.
I will try, my lord. After some time, I have tried.
Dr. Here I am praying for 3 weeks time to file my affidavit.
On the prayer of Mr.
R.S. Rongham,
Asir Ranghan, Learned Council,
KAC.
KAC. List this matter after 3 weeks so as to enable him to file counter affidavit.
Affidavit.
Non appears to the prisoner on call. Huh? First.
Deeply obliged.
Non appears to the prisoner on call. Next, then Mr. So and so. On the prayer of so and so, list this matter so and so. 3 weeks so as to enable him together.
Please, Your Lordship. First of all, the last occasion, the railway was supposed to file Philippine opposition.
Lordship, we have just received the instruction, Lordship. Lordship may allow us to file affidavit in opposition on the next date, Lordship.
Heard Mr. So and so, Learned Council for the petition. MS
N.T. Manpung.
Learned Council for the
On behalf of the learned
Learned
CGC
Council,
Bideka.
on behalf of Learned Still
CGC Bideka.
CGSC,
For all the respondents.
MSB Deka,
Mr. Bideka.
B Deka,
CGC Council.
for respondents. List this matter after 4 weeks so as to enable the respondents to file their affidavit. 4 weeks.
Deeply obliged, Lordship.
Obliged, sir.
May I please, Your Lordship?
Yes.
My Lord, I have a petitioner has filed the application for partition of his land. My Lord, no affidavit has been filed, counter has been filed. Instruction has been.
Instruction yet to receive, Lordship.
Any no consideration as of today?
My Lord, till date I have no instruction, my Lord. That is why.
Heard Mr.
J. Sharma, my Lord.
J. Sharma, Learned Council for the MS
S. Borua.
S. Barua, Learned State Council.
2 and 5 for respondent
State
number 2
Council.
and 5.
Request for him is granted 3 weeks time to file affidavit in opposition. List after 3 weeks.
My Lord. Obliged, sir.
Yes. None appears for the petitioner on call. Respondent who is for health department?
B. Gogoi is appearing for health department. I am for 2 and 3.
Yes. It's an eviction. What had happened?
Health department supposed to file affidavit, Lordship.
Yes. Where is
Yes.
Where is Health Department? Where is the Health Department? Yes.
But my instruction is evicted otherwise. Lordship is posted after vacation, after the winter vacation.
In the prayer of not appears for the petition.
My lord, Mr. A.C. Burrow, I'm appearing.
So and so appears for the petition. Huh? Mr. R.C. R.C. Learn consent for the petition. Appears for the petition. Mr. B. Gogoi, learn standing from the Health Department. Has pressed for and is granted for the 2 weeks time, 3 weeks time to obtain instruction. Just after 3 weeks.
I am going to that.
Yes, you mentioned. ML Bora. Yes.
Matter pertains to non-payment of the higher size lordship, no affidavit has been filed.
No affidavit.
We have received instruction, Lordship. We'll file affidavit. Within
Non-payment
3
of
weeks.
Higher size amount, your lordship.
Archers. Yes. What is the affidavit? What affidavit?
We will file affidavit within.
What does it say? Are you admitting?
It says, Lordship,
Disputing.
disputing, Lordship.
Or Mr. L. Mohan, learned counsel for deputy. MS. S. Bora.
as Borua.
S. Borua, learned state counsel. Submits says she has received the instruction which indicates that the amount claimed by the petitioner is disputed. She pressed for that she pressed for 3 weeks time to file affidavit to bring on record the instruction by way of affidavit. Praise the Lord. This matter after 3 weeks. Okay.
44, my lord, I am appearing for respondent numbers 1, 2, 3, my lord. I have entered appearance. Will I pray for some time to, my lord?
None appears on call for the petitioners. Mr. Gupta.
My lord, H. Gupta.
H. Gupta. Learned counsel. CGC.
CGC. No, my lord, I am for IUC, my lord.
Learned counsel.
The Indian Oil
Enters
Corporation.
appearance on behalf of
Respondent numbers 1, 2, and 3, my lord.
1, 2, and 3. We press for some time to file response.
No.
Praise the Lord. This matter after 4 weeks.
My lord.
May I please, Lordship?
Yes.
Lordship, respondent have filed the affidavit and the amount is admitted, Lordship.
Which one?
Lordship, item number 53.
Yes.
Affidavit page number 20, para number 6, Lordship.
Page
20. Filed
Yes.
by the respondent number 3, Lordship.
affidavit.
Yes, Lordship.
Page number 20 of the writ petition.
No, Lordship. Page number 20 of the affidavit, which is filed by the respondent number 3, Lordship.
Yes.
Para number 6.
Yes.
This amount is admitted, Lordship. And Lordship, this honorable court passed order On 3/5/2024, that amount is admitted. On 3/5/2024, this honorable court also passed an order.
Which one?
On
Where?
3/5/2024.
In this proceedings?
Yes, yes, Lordship.
3/5/2024.
This honorable court passed an order. That amount is admitted.
Three?
3/5/2024.
There's no 3/5. Where is 3/3?
3/5.
There's no 3/5.
There's
no 3/5. Yes.
Well, we have filed affidavit in WPC 5408 of 2020 by respondent number 2.
Who has to pay?
No, it's an sub-estimate against the main estimate. Main estimated amount has already been released. It's a sub-estimate of additional work done by them. For that amount of rupees, they are claiming 40,02,000, 40 lakh 2,000. Against then a report has been called for from Deputy Commissioners of Kamrup Metro and Sunitpur. So those reports are awaited. Only after getting those reports, this additional amount can be processed. She is dealing with she has filed the affidavit.
May I plead the Lordship, according to the telephonic instructions, the required information which are not received from the Deputy Commissioner's office, Your Lordship, they are still awaited. In the meantime, Your Lordship, the Water Resource Department has forwarded, they have filed an affidavit, Your Lordship. They have forwarded all the necessary requirements to the DC. Thereafter, the DC will be forwarding the same to the revenue and then the payment.
So the revenue will be paid
We are sending continuous reminders to the DC's
So
office.
who has to pay? You?
Lordship, the Water Resource will deposit the money. We will just disperse the money.
Who has filed the affidavit? Respondent number 3? Respondent number 3. So you said at para 60, para 6, you said it's 14 lakhs.
14,40,580.
14,40,580. This is what you are claiming.
Yes, yes, Lordship.
Yes, have you seen this?
Lordship, one more problem. The Deputy Commissioner is not a party in this writ petition, Your Lordship.
But we have filed IAM and the cost title has also been filed. We have made party.
Then this morning, I made a call, Your Lordship. The report has been sent from the Water Resource Department to the DC, and now the DC will be forwarding to the revenue. Because the proposal was not received from the DC, Your Lordship. That's why the delay has been incurring.
No, the ex post facto grant has been, approval has been already granted. For 14 lakhs 40,000. This is the amount you are claiming.
Yes, yes, Lordship. This is the amount. And Lordship, we have
Affidavit filed by respondent number 3. Respondent number 3 is
the Chief Engineer, Water Resource Department.
Assistant Chief Engineer. Madam, you check up the
No,
serial
Your
number.
Lordship, there is a
Para
confusion.
6.
Exactly, Your Lordship. The document which they have annexed, this is there, Your Lordship. But then freshly, the whatever the proposal I have mentioned in the affidavit, Your Lordship. The reminders are also annexed, Your Lordship. Would kindly come to page number 22. Page number 22.
Affidavit filed by whom?
Page number 20. This is affidavit filed by respondent number 2. This is dated 26th of November.
Lordship, in this record, page number 22, they have asked.
Page number 23, Your Lordship, there is a reminder sent to the DC and the chairman of the District Disaster Management Authority. So this has not been responded yet by the Deputy Commissioner. That's why the delay is incurring. Page 23, Your Lordship.
But this letter was forwarded on 23rd of September, and on that day the case was also listed, Lordship.
Anyway,
And
we'll
come-
wait for some time, let them clear.
Lordship, come
their
to page
formalities.
number 22. They have asked for granting another 8 weeks, but already 8 weeks have completed, Lordship.
We'll grant them another 3 weeks. Final. Let them complete their process. What they are not objecting, right?
Yes, Lordship.
What they are saying is, let them complete their process. That's all. They are not disputing. 3 weeks. 3 weeks. All right.
That may be fixed, Lordship.
Huh?
That may be fixed.
Lordship, we have not received a copy of writ petition, Lordship. Deputy Commissioner is made impleaded party, Lordship. And
A copy has been given, steps has been taken, Lordship.
You give her now.
and Lordship, in
Or
cause
Mr. MS
Diangana.
Learned Council for the petitioner.
S. Borua, I am for Deputy Commissioner, Lordship.
Mr. MS S. Borua, London State Council appears for a deputy commissioner who has been newly implemented, the S. Borua, London State Council appears for the deputy commissioner who submits that he is yet to receive the extra copy. Mr. MS so London Council for the petitioner to furnish the extra copy to MS S. Borua. You just furnish the extra copy.
I have served and notice.
It's all right. What's the big deal?
Okay, Lordship.
It's not that voluminous.
Yes, I will, definitely.
Lordship, part payment has already been
During
done.
the
Only the
course of the
remaining
day.
amount.
MS N. Bordolo, Learned State Standing Council for Revenue Department submits that she is waiting for the response from the Deputy Commissioner
Deputy Commissioner. Yes, Your Lordship.
for completion of the formalities for making the payment of the the claim amount to the petitioner. Therefore, she prays for further 3 weeks' time to complete the process.
may I please, Lordship?
Mr. So-and-so for so-and-so. Huh?
May I please, Lordship?
Considering the submissions of Learned Council parties, let this matter be listed after 3 weeks.
Lordship, date may be given, Lordship.
May I please, Lordship?
3 weeks. Huh?
Name of Zia Assam may be shown in that cause list, Lordship. Our name
You are
has.
appearing today. What's the problem?
Yes, Lordship.
After that.
Registry to reflect the name of the
Zia Assam.
Huh?
G.A. Assam.
Learned Government
G.A. Assam.
Advocate Assam. In the course list. Yes.
Oblige, Your Lordship.
53, 54.
Yes,
Same.
54 is similar matter, Lordship.
It will be in the common. I mean, it will be common order.
Yes, Lordship. Oblige.
Sir, it you mentioned, my lord, item 31, my lord, we could not file the FPTCL, HC FPTCL. Let the matter be listed.
Which one?
Item 31, my lord.
Why?
Because a standing announcing FPTCL is not available, my lord, today. Let the matter be taken day after tomorrow, my lord. Item 31, my lord.
We'll see. Timing, we'll see later.
Oblige.
Yes.
Lordship, we'll file reply affidavit in this petition, Lordship. And they allow some time after, let this matter after come up.
On the prayer of Mr.
A.D. Chaudhary.
A.D.
Chaudhary.
So the Learned Council for the petitioner list this matter after 4 weeks so as to enable him to file affidavit in reply.
Yes, Lordship. Always, Lordship.
May it please, Your Lordship.
Yes.
Lordship, the respondents either filed an application in opposition. We would like to file a reply.
On the prayer of Mr.
A. Borbujari.
Learned Council for the petitioner list this matter after 4 weeks so as to enable him to file affidavit in reply.
There's an interim order, Your Lordship.
Interim order first, earlier shall continue.
Deeply, Your Lordship.
is your lordship.
Yes.
In regarding this matter, lordship, we may be allowed to take fresh steps as well as amend the cost title, lordship.
For amendment, you file a application.
Yes, lordship, we may be allowed to file.
Or Mr. So-and-so. No, only Mr. So-and-so is pressed for and is granted. No, Mr. So-and-so, learned counsel is permitted to take fresh steps for service of notice about respondent 5 and 6.
Yes, lordship.
Mr. So-and-so.
I'm for respondent 4, Lordship.
Appears for respondent number 4. This is the matter after 4 weeks. In the meantime, whatever you want to do, you do. You may file the right?
Obliged.
Obliged, lordship.
No appears for the petitioner on all. Office note, the order of the Lauzimo court dated 24 dated 05/12/2024 indicates that the petitioner has failed to take steps for service of notice upon respondent number 4 and 5, despite order of the court as well as the Lauzimo courts for 3 consecutive times. Let the matter be listed after 3 weeks by providing an opportunity, last opportunity, petitioner to take steps for service of notice upon respondent. In case, in the event of the default continues, appropriate orders shall be passed. In the next step. Respondent sends a police. Yes.
May I please, Lordship?
Yes.
Yes, sir. Service of notice upon respondent number 11 is completed, Your Lordship. Respondent number 11 is complete, Your Lordship.
I entered appearance respondent number 11.
Okay.
And then in respect of respondent number 679, they have filed their affidavit in opposition. I would like to file my rejoinder, Your Lordship.
Heard Mr. Swenson, Land Council. Mr.
S. Decker.
For the person who submits that he may be granted some time to file affidavit in reply to the application filed by the respondent. Respondent 5, 6, and 7.
6, 7, 9.
Filed by myself, Lordship, 4, 6, 7, 9, 10. EPF Commissioner. Philip Day. Mr. D. Day.
D. Day. Yes, for respondent number. So and so. 4, 5, 6, 7.
4, 6, 7, 9, 10. EPF Commissioner.
Mr. Land Council enters appearance on behalf of respondent number 11. This is the matter after 4 weeks. In the meantime, parties may exchange their
In this case also, Your Lordship, service upon respondent number 6 and 10 is complete, Your Lordship.
Are you appearing?
I think 50.
50.
Yes, for PNRD.
For
PNRD.
Heard Mr. Swenson, Land Council. Mr.
AK Ghosh on behalf of S. Datta.
For Swenson and MSS Barua. Are you not? You have filed the affidavit. Service completed. Service completed. Respondents release the matter after 4 weeks. In the meantime, respondents may file the. Yes, next.
Obliged.
May it please your Lordship. Yes. This matter, my lord, the main writ petition, my lord, originally deals with, my lord, management and worker dispute, my lord. Some 16 workers were terminated by the erstwhile ASTCL, my lord. So, my lord, the matter was referred to the Labour Tribunal. Labour Court held in their favor.
What is IA for?
IA is for substitution, my lord.
Okay.
So, my lord, what happened, my lord? The Labour Court said that the termination was illegal. Challenging that, my lord, the ASTCL filed a writ petition, my lord, in the year 2014. Thereafter, my lord, in the meantime, my lord, ASTCL was acquired by AIDC, my lord, Assam Industrial Development Corporation, my lord. ASTCL was closed down, my lord. So we have filed this IA for substituting our name on behalf of this, my lord, ASTCL, my lord. So on the last occasion, my lord, the Honorable Court wanted to know the manner of acquisition, my lord. So I have got some instruction, my lord. I can place that.
Lordship, the same may come in shape of affidavit so that I can respond because I am for the workmen. We are the beneficiary of the award.
Yes.
What happened? One annexure has been annexed to the application, which clearly spells that out of the available fund, Lordship, at page 15, Lordship, annexure 1. Lordship, the second paragraph.
It's okay. If you want to, it should be you by filing
affidavit,
then you consider.
so that I can.
That will be the basis for whether you should be allowed to substitute or not. Whether the application you file that. Mr.
S. Das,
Mr. S. Das, Land Council for the applicant submits that he may be granted some time to file to bring on record the instruction by affidavit as the instruction would be required to determine as to whether the present application can be allowed or not. But the 3 weeks time is granted. Mr.
Lordship, may I pray for a date, Lordship? We are the workmen, we are suffering, Lordship. We are the beneficiary of the award, Lordship. We are expecting our
Mr.
as Chakraborty for 4 to 18. That's one number 4 to 18.
You are the one who has asked, suggested for file.
Lordship,
Otherwise, you can
the instruction, this is going on for last 3-4 months. As per order dated 11-14. So, maybe.
No, you are the one who has asked, indirectly asked, asked that they should bring on record this instruction.
Lordship.
You can peruse and we can
No,
decide.
a short date may be given, there's no submission, Lordship, if possible.
Are you objecting, seriously objecting the substitution?
Yes, because what happens, Lordship, as per the award was passed by the Labour Court.
Okay, thank you. In that case.
Okay.
Highly object.
Lordship.
May I please, Your Lordship?
Yes.
In this matter, this honorable court has directed to take steps through drastic surveys as well as the usual courts and other
Yes.
way, my lord.
Ah.
In so far as respondent number 7, 10 to 16 is concerned, we have served only respondent number 16 has received the notice and other persons, Lordship, refused to accept the dusty. We have filed an additional affidavit matter on 15/7/2024.
Yes.
Lordship, as they are refused to accept the notice, my lord, this may pray for, may be deemed to be served, my lord, notice upon the respondent number 7, 10 to 15. This is my prayer, my lord.
7, 10 and
7, 10 to 15. 10 to 15.
to serve. What are you saying?
Lordship, we have served notice through dusty, my lord. But only respondent number 16 accept the notice and 7, 10 to 15 refuse to accept the notice.
Where
my
it
lord.
is?
Lordship, I have filed additional affidavit on 15/7/2024.
Service of notice upon respondent 7, 10 to 16.
Lordship, only 16 received.
Where does it say? From where we can make out that they have refused to accept.
Lordship, para 2, we have stated and also annex the return memo. Page number 138 onwards, the return memo.
Yes. Then
Also, may I pray before Lordship, my lord? Notice upon that these respondents may be deemed to be served.
our MS consulted the petition. Office note dated 6/1/2024 reflects that the ID card in respect of no any answer. No, neither ID card nor answer notices have been received back in respect of respondent number 7, 10 to 16. Mr. It also reflects that an affidavit has been filed regarding the dusty service upon respondent number 7, 10 to 16, 7, 10 to 16. While it has been filed by the petitioner stating that the respondent number 7, 10 to 15 have refused to accept the notice in the presence of witness except the respondent number 6.
16.
Next one. Having perused the affidavit filed by the respondent, the petitioner. Wherein a categorical statement has been made that the respondent number 7, 10 to 15 have refused to accept the justice notice which was through Dusty Mail. The notices are from the respondents number 7, 10 and 10 to 15 are deemed to be served. They are deemed to be completed. They are deemed to be served and completed. That's all.
My name may be recorded, Lordship. I am for respondent number 8 and 9. MK Hussain.
So and so,
MK Hussain.
then consent. At least for respondent number 8 and 9.
8 and 9.
Lordship, my senior counsel's name may be recorded. SK Talukar.
For state.
Corporation.
For
Corporation
state
Department.
respondents.
Corporation Department, my lord. Corporation.
List the matter after 3
Date
weeks.
may be fixed.
In the meantime, parties may send the affidavit.
Date may be fixed, my lord. A date may be fixed.
My lord, in this case, we have filed an IA for vacation of an interim order. My lord.
Yes.
If your lordship kindly takes the IA 3444 of 24.
344.
Yes.
0.
Yes.
Yes.
My lord, the writ petitioner is the original owner of a particular property in JS Road, Guwahati, my lord. They had a lot of, my lord, dues to the financial institutions and other dues. So an agreement was entered into between the writ petitioner and the applicant, whereby, my lord, more or less about 10 crore was paid to the writ petitioner, and thereafter, my lord, the property was handed over. Now, the agreement to sale is at page 36. If your lordship would kindly come to page 38. I'll read the first sub-parameter. Whereas the total outstanding loan amount payable against the loan account of Central Bank of India, Guwahati, stands at rupees 391.86 crore and cash credit of 2.77 crore as on 31/3/14. Whereas the first party paid 2.17 lakh by selling 3 numbers of collateral property after NPA and paid 19 lakhs to Tata Capital Financial Services Limited. And whereas first party has also taken loan from Tata Capital Financial Services Limited for running the business on the said RCC building, and the principal amount which was sanctioned and disbursed in favor of first party was 5 crore, and after making payment against the said loan amount, the total negotiated amount stands at 5.15 crore as on 8/8/17, of which 65 lakh was paid on April 27 and balance 4.5 crore to be paid by October 15. So as per the, my lord, the arrangement, as far as Central Bank is concerned, this two amount comes to 6.69 crore, and my lord, the Tata Financial Services, it comes to about 4.5 crore. So total comes to about 11.19 crore. Then my lord will kindly come to page 39. And whereas the first party, due to loss in their business and because of financial constraint, could not liquidate the outstanding loan liabilities to the Central Bank of India as well as Tata Capital Financial Services Limited. Then last subpara. And whereas first party has offered to sell the plot of land measuring 2 kata 10 lesa along with the building as mentioned in Schedule A below to the second party, that is respondent number 8 applicant, for enabling them to pay the outstanding loan amount to the Central Bank and Tata Financial Capital Services Limited. So, my lord, it was 1 crore to actually. No, no. Oh, ah. Then, my lord will kindly come to page number 41. On top, that the second party shall pay an amount of rupees 1 crore to the first party for enabling him to pay the amount to the Central Bank of India against the loan amount standing against them for the purpose of seeking OTS of the outstanding loan amount standing against them, and on receipt of the OTS proposal from the bank, the same will be paid by the second party within the scheduled period as may be provided by bank as OTS. Para 3. That against the total outstanding loan amount of 5.15 crore to Tata Capital Services, the first party shall pay an amount of rupees 35 lakhs and the balance 4.5 crore will be paid by the second party. Then this para 5 is important. Second party will have the right to take possession of the land and building as mentioned in the schedule below on and from the date of payment of rupee 1 crore as mentioned in paragraph 1 of this agreement. Then Milord will kindly come to page 42, para 7 and 9. That it is hereby agreed by both parties, first party and second party, that second party will be entitled to run any business in the scheduled land and building mentioned herein below, and the first party will be given a share of the said proposed business by the second party, and share percentage of the first party will be decided amicably by both parties. 9. Proposed of OTS by first party has been proposed to the Central Bank of India at 5.6 crore, which may extend up to 6 crore by bank. So, my lord, by virtue of this agreement, an amount of upfront payment of 1 crore rupees was made by the applicant, my lord, to the petitioner. Just to Lordship knows, whenever any OTS proposal or something is sought, some down payment is insisted upon. So with that money they have done. Subsequently, my lord, page 45 to page 64, we have paid the amount almost more than 10 crore. And then, my lord, I am running a hotel. And my lord, as far as GMC land revenue, GMC dues, land revenue, APDSL liability, everything has been cleared by the applicant. Then fire safety, trade license, occupancy certificate have all been issued in the name of respondent number 8. Now, my lord, they filed the writ petition by suppressing this agreement to sale, my lord, and obtain and stay order, which your lordship will find at page number 32, my lord. Operative portion is at page number 35, my lord. Considering the facts and circumstances, this court is of the view that equities would be balanced and the interest of justice would be served, directing that though the process for consideration of issuance of trade license on the basis of the impugn NIC is not put up to any hold, no final order of trade license to the respondent number 8 be issued without taking leave of this court. Now, my lord, I have paid the money, there is an agreement, no mention in the writ petition regarding all this. And my lord, interestingly, they have filed an objection to our IA where they are trying to say that they have not carried out one clause regarding how the profit should be apportioned between the, my lord, writ petitioner and the applicant. Now, for that, they are relying on, my lord, the agreement to sale. But for other claim of the writ petitioner, they have suppressed. So what is there in this case, my lord? Who are you to stop my trade license? I have bought a property from you. Everything is in my name. Now, because of this stay order, my lord, the trade license has not been issued. My lord, I have invested more than 10 crore. And if you have got any difficulty, go and file a civil suit. So what is there to approach this honorable court, my lord? They are relying upon an agreement partly. Now, let them show one averment in the writ petition that there was an agreement to sell pursuant to which the property was given in the manner as indicated in the my lord, agreement to sell. And my lord, the fact that we have paid the money, that has also been suppressed. So my lord, for non-disclosure of candid disclosure of facts, this is not even entitled to hard-on merits. No, it is I'm a bona fide purchaser, my lord. I'm for value. Things are going on. Now you have come to a writ court. Now what is that public law element involved in this case, my lord?
Your response number 8.
Yes. Now what is that public law element involved in this case that you are invoking 226 jurisdiction of this honorable court? If at all there is any dispute, it's a civil dispute. Go and hesitate to file a suit. I don't think, my lord, even this writ petition is maintainable. Now, because of the interim order, my lord, I have not been able to acquire the bar license. Then, my lord, trade license is on hold.
Yes, sir.
My lord, only relying on one judgment, my lord, that KD Sharma's case. Please come to para 34 for a moment, my lord. At page 492, the jurisdiction of the Supreme Court under 32 and of the High Court under 226 is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of the relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. I'll be relying on the judgment. Well, at least he should have made a disclosure in the writ petition that a substantial amount has been paid and he has received it, and we have paid it to the financial institutions.
Lordship, in my writ petition, if your Lordship perishes page 28, I have already enclosed a copy of the agreement which I have entered into with the respondent number 8. What I say in my writ petition, if I may please read, Lordship, it has been stated that I have suppressed the fact of the agreement before this court. No such suppression was made, Lordship. Paragraph 5, page 6 of my writ petition, if I may please read. That your humble petitioner begs to state that the petitioner had entered into an unregistered agreement with the respondent number 8 for sale of a part of the said property, and it is pertinent to mention here that it was agreed amongst them that the petitioner shall be given a share on the business proposed to be carried on by the respondent number 8 from the said property, and the share percent shall be decided amicably by both parties. It was further agreed amongst both parties that commercial constructed space measuring more or less 800 square feet on the 4th floor of the said property, along with 4% car parking space, each on basement floor and ground floor, shall be retained by the petitioner. Now, Lordship, when this agreement is being entered between the petitioner and the respondent number 8, it is regarding 4 floors of a building situated on GS Road. In principle, they had agreed that the part payment of the loan, which was already made by the petitioner, after that there were some dues. Those dues the petitioner could not clear. Those dues, to clear those dues, he has decided to sell his property to the respondent number 8. So this agreement was entered into. So part dues was paid by the petitioner earlier, part dues was paid by the respondent number 8 subsequent to this agreement. Now, Lordship, as soon as we talk about this agreement, there is a consideration in the agreement at what consideration the property is to be sold. It has been stated that the loan was partly paid as agreed in the agreement. But when the said agreement talks about the share of business which is intended to be carried out from that property, that also becomes a part of the consideration which is arising from that agreement. Now, what we are saying, they state that we are not stating about the money part. We are not even agitating or disputing that they have not paid. They have paid the money part, and now they have forgot about the sharing business part, and now they will take the entire property, forget the part of property which was retained by me, forget the share of profits that was supposed to be paid to me and was to be amicably agreed with me before starting the business event. They will take the statutory authorities in their hands and they will influence them to issue the licenses illegally. It is my building. They have obtained an occupancy certificate in their name without any ownership right. Because misusing the online trade license facility, they have obtained the trade license. And they have illegally started the hotel and accommodation business, restaurant business. Now, when I have come to know about the same, I have filed a series of representations before the GMC authorities. They have given a deaf ear to my representations without considering even the same. They have again issued an NOC that they might be proceeding to issue the bar license to the respondent number 8. So, do I not even deserve a fair chance of hearing before the GMC authorities? They will not consider my representation and they will not even pay my consideration.
But then that consideration at best would be a breach of contract or certainly the stipulation.
Lordship, they have entered into an agreement with me. And if they want the
Have you
property,
filed any suit before the appropriate court?
Lordship, filing the suit will be their
The
prerogative
simple
because
issue is your representation has to be considered by the GMC authority.
by the
That's all.
GM, no, the issuance of illegal occupancy certificate. I am the owner. How can the occupancy certificate be issued in the name of respondent number 8 when they do not have the ownership right? It cannot be. Trade license until the owner does not
So
object.
we'll decide, suppose there is agreement to sell, an agreement is there and the money has been paid. If it is not complied, I mean, it is a breach of, I mean, whatever stipulation in the contract, I mean, the sell did. And the agreement, who will decide?
The owner's objection, Lordship, always the GMC has to decide because they are issuing the licenses and approvals.
We'll close the petition, will grant the liberty
Yes.
to the GMC to consider the representation, but no state.
No,
Yes.
Lordship, there are 3 grievances which I have put up in this petition. Number 1 is the
No,
illegal.
one could understood that if you have approached the appropriate court and placing those materials before the GMC authority, since the issue is under the before the appropriate competent court, the matter would have been different.
Can be seen.
You have not filed anything except
No,
objecting before the GMC.
Yes, I have filed a series of representations before GMC. Since I had agreed that if you pay the loan, I will hand over the possession. I have done my part. Now, if they want to carry the business without complying with the agreement, they have to take the ownership of the property. They should file a suit for specific performance. And Lordship, the GMC is always bound to consider the owner's representations. And until and unless I have not filed an objection, they will not know that the owner might object. After filing a series of objections, they will keep doing this. So Lordship will see all the documents which are annexed with the writ petitions as well as the IA. They are stating in the IA that they have paid 10 crores. There was an enforcement directorate proceedings against them where they have stated they have paid 8 crores. They are making misleading statements before this court. How will this court decide? Until and unless the court does not
That's
go into
exactly
the-
why you wonder. We are wondering exactly what.
the court has to go into those documents, Lordship, to examine those documents in detail.
We cannot. We cannot.
Lordship cannot give a straitjacket license to GMC authorities to do whatever on behalf of
So,
respondent number 8.
what is the under the law, what the GMC is supposed to do? Any rules, any regulations, any
Lordship, this license,
notifications?
trade license is issued under section 180 of the GMC.
Yes, was. We'll continue at 2.
Lordship.
Sure, pardon, the item 44, my I was engaged in some other court, my it has been for my presence.
We'll see later.
God bless you.
Hi. 1971. Your Lordship can go through this. Lordship, section 378, subsection 3 will be relevant. It says that whenever the commissioner, it is pointed before the commissioner that some licenses or written permission or approvals have been obtained by way of misrepresentation or fraud. Those licenses or written permissions shall stand revoked or cancelled by the commissioner.
Has he obtained the license?
Yes, Lordship.
Has he obtained
He has
the
obtained
license?
an NOC. Lordship will peruse page 80 of my writ petition,
It's
Lordship.
okay. It's an NOC or license?
It is an NOC, Lordship. For the obtaining of license, this NOC is mandatory. And for not giving this NOC, I have filed several representations.
This is
Lordship.
for suspension or revocation of the license?
Yes, Lordship. And in this writ petition, I have also challenged one trade license which has been obtained by them. I have challenged 3 things in this writ petition, Lordship will note. Number 1 will be the trade license for the Hotel Apollo Grand, which carries on the business of accommodation, lodging and fooding. Now, I have also challenged a grant of NOC, which is required for obtaining license for bar. And then I have challenged an occupancy certificate for the building, which has been illegally obtained in their name or by mistake whatsoever.
Mistake or illegal?
I say illegal.
But you said mistake also.
Might be so.
Mistake and illegal are not same
No,
thing. It's
Lordship,
not synonymous.
GMC affidavit is not yet on record. So it might be their submission. I say that it has been illegally obtained by them.
But that, sir, you have the appropriate remedy. If you are questioning the
Lordship will just listen me.
veracity of
Listen
your
to me.
sale deed or the transaction you have.
After going through section 378, Lordship will peruse page 80 of my writ petition, Lordship, the NOC which I am talking about, which has been challenged in this writ petition.
Yes.
In the writ petition, Lordship.
What is your objection?
The
What
NOC
is your objection in the vacating of this?
I would just point out 2 documents, Lordship. Page 80 of my writ petition, there is a to whom it may concern, Lordship. Lordship has found that?
Issuance of the final order has been stayed.
Milord.
Issue of the final order has been.
Yes, yes.
And they are
stayed.
already carrying on the hotel.
The process is not been, NOC process has not been put on hold.
Yes.
They want it without the
And
process.
let my
Lordship.
learned friend conclude. I'll take 5 minutes time.
They want it without the process. All through they have done it without the process, Lordship.
Anyway, we'll see that.
So Lordship has already gone through page 80. Lordship will also peruse page 77, Lordship. GMC had stated that respondent 8 had preferred an appeal, Lordship, because of non-issuance of the NOC as regards the bar.
Page
77 of the writ petition, Lordship.
77.
Page 80 is the NOC, which was issued after page 77, Lordship. The Lordship has gone through page 80. Says the Guwahati Municipal, page 80, Lordship. The Guwahati Municipal Corporation has no objection in allowing to run the trade of an IMFL on bar cum restaurant in the name and style of Messrs. Creep, proprietor so-and-so. That is the respondent 8, at ground floor of Hotel Apollo Grand, situated at GS Road, under ward number so and so, holding number so and so. Within GMC. Number 2 says, in case if any public complaint arises or any undesirable activities detected against the said bar cum restaurant IMFL on, GMC shall have the right to cancel the NOC along with the trade license granted if any. Lordship, this NOC was issued after page 77. Lordship will produce the order.
Yes.
If I may please read, Lordship. The appellant has preferred the instant appeal on being aggrieved by non-issuance of NOC by the authority for bar cum restaurant at Hotel Apollo Grand. As a matter of fact, no order has been passed by the authority as on date. The appellant has been heard, also perused the materials on record. So it says that respondent 8 had filed the appeal, Lordship. I was never given a copy of appeal, still I have given a representation, Lordship. It transpires that the property on which the aforesaid hotel is running does not belong to the appellant. Rather, the same is being used by the appellant by virtue of an agreement with the owners of the property, that is so and so, subject to certain conditions specified therein. It is also on record that so and so has objected to grant of occupancy certificate dated 3/1/22, issued erroneously to Srimati Anjana Bora. She has also not produced any NOC issued by Sankardev Commercial Private Limited. On a perusal of the agreement dated so and so, executed in between Sankardev Commercial, represented by Devabrata Talukdar and Khanivra Talukdar on one side, and Srimati Anjana Bora, proprietor Brahmaputra Television Network, that Sankardev Commercial Private Limited will be given a share on the said proposed business by Brahmaputra Television Network, and the share percentage of the first party will be decided amicably by both the parties. However, in the instant case, there appears to be no NOC from Sankardev Commercial, represented by so and so, to run any business. Nor there is anything to suggest that Sankardev Commercial has been given a share on the said proposed business as per agreement. Moreover, the hotel in question is under attachment by the Enforcement Directorate in pursuance of order number so and so dated 30/3/22, arising out of FIR number 8/17 dated 20/10/17, registered by Chief Minister's Vigilance Cell. In the circumstances, the matter is directed to be placed before the Commissioner, GMC, to examine the matter and pass a speaking order, either allowing or rejecting the prayer of the appellant at an early date. After this was placed before the Commissioner, Lordship, I have also placed a representation filed by me at page 78, because I was served with the copy of the page 77. And after that representation was filed, Lordship, page 80 was issued. As if it is a normal NOC, there is no dispute between the parties, between the owner and the occupant. It has been issued in a mechanical manner, Lordship, without passing a speaking order as suggested in page 77, Lordship. And I have not challenged the page 77, I have challenged page 80, Lordship. So the matter may be remitted back to the Commissioner to pass a speaking order in the matter. Setting aside this page 80.
Your challenge is NOC only.
I have challenged the NOC. That was the first challenge, Lordship. Subsequently, I have challenged page 56, Lordship.
What subsequently?
Page 56, Lordship.
In this proceedings, what's your challenge?
Lordship, I have challenged the issuance of the occupancy certificate. An occupancy certificate is a document, Lordship, which is issued by the GMC, which says that the building is fit to be occupied and there is no violation as such. It is such document, Lordship. But this occupancy certificate is issued in subsequence to the building permission that is obtained, Lordship. And it is issued in favor of the same person in whose favor the building permission is issued, Lordship. So page 56, your Lordship will note, has been issued in the favor of respondent number 8. Now, Lordship will peruse page 25. which is the building permission of the building, Lordship. Page
I have stated this.
26. Translated copy is at page 25, original copy is at page 26, Lordship.
आता ऑप्शन पासेस झालो की त्यांना मग बिलिंग परमिशन नाही.
So this building permission was issued in name of Sontonja Construction and Services Private Limited. So it is a thumb rule, Lordship, in whosoever's favor the building permission is issued, the occupancy certificate is issued only in his favor. Now, how they have obtained this occupancy certificate in their name, that can be only suggested by GMC authorities, Lordship. So this is my second challenge, Lordship, to the occupancy certificate which is issued in the name of respondent number 8.
It's issued in 2005.
No, 2005 was the building permission, Lordship. I am challenging 56. 25 I am relying upon, Lordship.
Okay. This was in your favor.
Lordship, the building permission was issued by Sontonja Construction and Carriers, who was the builder of the building. I purchased the entire building except one floor. And from
he has purchased from you.
He has not purchased, he has agreed to purchase, Lordship. So page 56 was the another challenge which I have pointed out to your Lordship. Now there was a trade license which was obtained by them, which is at page 55 and 55A, Lordship. If I may please read, Lordship. Subject to the provisions of GMC Act and rules bylaws made thereunder, a license is hereby granted to Srimati Anjana Bora for business type hotel having 31 beds to 50 beds. Name of the owner, Hotel Apollo Grand, a unit of Satyam Associates, address so and so. Now, Lordship, for issuance of this trade license, I have come across a judgment of this coordinate bench of this court. It says that for issuance of trade license, Lordship, 3 documents has to be submitted. Paragraph 5 says, Lordship, the nature of documents which needs to be submitted for obtaining trade license. There are 3 documents. The number 3rd says, Lordship, legal occupancy. I see that might be one reason, Lordship, that they have obtained somehow the occupancy certificate in their name, so that they can get all the business licenses by misrepresenting before the GMC authorities. There is a notification of the GMC which has been talked about in the judgment. For that purpose, I am relying upon the judgment, Lordship, 2017 notification. Since they do not have any other ownership documents, what they have done is they have somehow obtained the occupancy certificate in their name, and based on that occupancy certificate, everywhere they become the owner of the, pose as the owner of the building, Lordship, by ignoring the conditions agreed upon with me. For the other part of the judgment, Lordship, it is a dispute between landlord and tenant. So those liberties which a tenant gets might not be applicable in the case of respondent 8 because he is not a tenant.
This is a case where the application was rejected.
Lordship, that was a case between a landlord and a tenant. I am relying on paragraph 5 because of the notification of 2017 which specifies the nature of documents to be submitted for trade license. Because the petitioner in that case was a tenant and the respondent number 8 in this case, Lordship, is a permissive occupier who is now acting beyond the permission. Lordship will peruse that page 34 was the agreement which was pointed out by the respondent number 8, and at paragraph 7 he has also read that it is hereby agreed by both the first party and the second party that the second party will be entitled to run any business in the scheduled land and building mentioned herein below, and the first party will be given a share on the said proposed business by the second party, and the share percentage of the first party will be decided amicably by both the parties. So now what they are doing is, on the first part of the paragraph 7, they have all their rights that they can carry on any business, but their obligation and responsibilities under the second part of the paragraph 7, they have now tend to forget because it benefits them. If they are carrying on any business, and if I was supposed to be a shareholder in that business, how can they even start a business without making me a partner? So that has all been done illegally, which I have already pointed out before your Lordship. And they are already carrying on their hotel accommodation fooding business. So they are not getting prejudiced. Now they want to carry on bar. So that is why, since no authorities are listening to our representations, what other alternative do I have, Lordship, if I do not approach this honorable court? They may continue their business which is already going on in the bar license. The stay order may be kept intact, Lordship. Else they might show out how they have given the share of business to me. They may file an application if they can satisfy.
Yes.
That's all.
Yes.
Lordship.
Milord, I'll just take 10 minutes time, Milord. Now, my lord, what is the case projected by the petitioner? He says that the trade license, NOC, there is an all obtained illegally. Why he says it is illegally? Because his share in the business has not been apportioned and declared. That is his only grievance in terms of clause 7, number 1. Number 2, my lord, I made a submission regarding suppression of material fact. My lord, when in context of a 226 proceeding, a allegation is made regarding suppression, in my humble understanding, my lord, what is meant by suppression is failure to candidly disclose facts. Now, what is a candid disclosure of facts in the facts of this case? That there was an agreement. In that agreement, all that was agreed upon was the second party, that is the applicant respondent number 8, will liquidate the liability and he becomes the owner of the property. There is no other clause. Let us be very clear. Please come to the agreement, Milord, for a moment. I'll just place 2-3 clauses. Please come to clause 7. Page 42 of the IA, and in the writ petition, Milord, it is what this is. Milord will kindly come to page number internal page 7. I think it's a part of annexure 2. I think it will be 34, Milord.
No, I'm in IA now.
Okay, please come to page 42.
42.
Yes. That it is hereby agreed by both the first party and the second party that second party will be entitled to run any business. Kindly see, my lord, the language used. In the scheduled land and building mentioned herein below, and first party will be given a share on the said proposed business by the second party, and share percentage of the first party will be decided amicably by both sides. But regarding the second part of clause 7, there is no stipulation in the contract. If this is not done, what will happen? So consequence of non-fulfillment is not provided in the agreement. Now, but the first part clearly mandates that after signing of this agreement, I can do any business. Well, can I run a business without a trade license? Can I run a hotel without a bar license? These are all, my lord, necessary concomitants. These are ancillary, incidental to the main purpose. Now kindly come to, my lord, 9. The proposed OTS by first party has been proposed to the central bank at so-and-so, which may be extended to 6 crore by the bank. All liabilities as far as Sankardev Commercial Private Limited privately lies with the first party. Before representation, the liability needs to be cleared by the director of so-and-so. After registration of the said property, first party to second party, all liabilities even between the parties will stand null and void. All OTS proposals sent off by Central Bank of India, Tata Capital Services has been proposed after discussion by both the parties amicably. Therefore, my lord, this is an agreement not for any other purpose. It is an agreement for liquidating the liabilities of the writ petitioner and which has been liquidated. Now, where is that averment in the writ petition? When we say what is meant by candid disclosure of fact, that as a part of my obligation, the applicant has paid so-and-so crores of rupees to both the financial institutions and also paid 1 crore rupees for initiating the OTS proposal. Where are those? You have read a particular paragraph, you have only referred to the agreement. That is why, my lord, what is important, what is significant is whether there is candid disclosure of facts. Now, my lord, it appears the petitioner has a grievance that a share in the business has not been fixed. For that, you go to civil court. Or you take any remedy remedy available to you. Well, what wrong Guwahati Municipal Corporation has done when clause 7 of the agreement says that I am entitled to do any business? Can I do a business without a trade license? Can I run a bar, my lord, without a bar license? Why? What is the wrong GMC has come? Well, my learned friend is trying to read the provisions in the GMC Act as if a property belongs to A and why B seeks to start a business in that without these intervening facts. Well, I am someone like auction purchaser. So where is the question of, my lord, the billing permission would be in my name? It would definitely be known of the name of the owner. I have a person who has stepped in by virtue of this agreement and to which he agreed. Now, if in the agreement, if arising out of the agreement there is some dispute, then is it 226 a forum, my lord, for that? What you cannot do directly, you cannot do indirectly also. Please file a suit, go to civil suit, say that my share in the business has not been determined. Please seek a declaration. Why lordships will come in the way? Well, end of the day, my right under Article 19(1)(g) to do a business, there has to be a reasonable restriction. Does this mean reasonable restriction, my lord? And 226 is not for enforcing a private, my lord, grievance. You have a private grievance.
Have you asked for a share? Lordship? Have you asked for a share of your as per the agreement?
Yes, Lordship.
Very.
Presentations that we have filed before GMC, the only grievance that I have portrayed is that our share has not been given to me.
Then who is GMC to determine that?
I think GMC is not the authority
They
to
are not
decide
the
whether
authorities,
you are
but-
entitled to share or not.
But if someone does not,
It's amicably decided amicably about the. Why don't you decide amicably?
no,
If you want to
Lordship.
share, you ask him.
Lordship, if I ask him and if he does not even pick up my call, I have stated
Oh,
in my writ petition
it's
that he has stopped
unlisting.
responding to my calls even. So if that is so, if I have ventilated my grievance to an authority and if it reaches to him by in any manner or so, he can also contact. He does not entertain my
He
calls.
doesn't want the share. He wants the one who wants a share. As per
Lordship,
the
but
agreement.
what
You should approach him.
He is claiming all his rights from paragraph 7 of the agreement, Lordship, which says that he can do any business from the property. But that right is coupled with an obligation, which he has not discharged.
Therefore,
Is it not his responsibility to discharge that responsibility?
Therefore,
Before he
go to civil court.
exercises his right. No, he does not wait to even ask. He obtains everything, he starts everything. If he is carrying on a business, if I was supposed to be a shareholder, there ought to have been two owners of the said business, but he files it as a proprietor. He obtains it illegally.
No, that is not the thing. That is not the clause.
It
That
says,
is your understanding
if I
of the
get a
clause.
share in the proposed business, there are two partners.
No.
I get one share, he gets one share. If he ignores all these conditions which are his onerous responsibility, his lordship, how can he claim protection from this code?
Sir, let us hear the
GMC.
petition after tomorrow. Read petition.
Lordship, if it can be any other day except day after tomorrow. Except day after tomorrow, Lordship.
Day after tomorrow is Wednesday. Thursday.
Look, Thursday I'll not be there. There is some
Whatever,
religious
Mr.
function
Bora.
in my place.
Have you filed your response? Instead of
No, my lord,
I
what I'm saying is, my lord, if my landed friend's grievance is not getting a share, what the poor municipality can do, my lord?
That's why I asked.
What poor municipality can do?
I have indicated. What he's saying is you are trying to obtain the trade which the municipal authority is supposed to
My lord,
do as per the rules and
my lord,
notifications.
he has entered into an agreement with such clauses. It virtually gives everything to the other party, my lord. And because you are in trouble, because your account was NPA rendered, otherwise everything would have gone.
But he does not talk about giving the share, Lordship. He
Yeah,
talks
anyway,
about everything
anyway,
else.
the
No, I am
share
not
having
saying
a-
that.
If you want the share, who is stopping you? Go and ask him.
Lordship, if
Discuss with him. It said amicably. Go and discuss
Lordship,
amicably.
if I got it right, the GMC has
If
got
you are not able
instructions.
to decide it, then we'll decide. I'll pass the order in IA.
Lordship, if I hear it right, the GMC has got instructions.
Yes.
If they have got instructions, Lordship, if they come before the court, it would be of help while deciding of the applications, Lordship.
You have the instruction. You have the instruction. What they say. So instead of keeping it pending, I thought we'll.
No, my lord, my humble submission is let this stay order be lifted and everything will be subject to the outcome of the case. Otherwise, my lord, my bar license is on hold, my lord.
It has to be on hold. His
No,
hotel
no,
also
no,
has to
no,
go,
no,
Lordship.
no,
Lordship, what I propose is that the matter be fixed next
Oh,
Tuesday.
I'll liquidate your dues and you
Matter
want to
will be
get back your
No,
ownership.
Lordship, he himself suggests that he's in the shoes of an auction purchaser. An auction purchaser, if he does not comply with his obligations, his
Okay,
advance
then-
gets forfeited.
No, which are the obligations which I have not performed?
then-
Please point out.
then
Where in the writ petition have you pointed out?
Lordship,
I'll pass the order.
Yes.
it can be next
Yes.
Tuesday,
No, no,
Lordship. And both the
Possible
things
pass
can be
the order in
decided
IA.
together, Lordship. Both writ petitions and IA can be
I,
decided
No,
next
I-
Tuesday.
I have heard both of you.
Yes.
I'll pass the order
Yes.
in the chamber.
Yes. Deeply obliged.
And Mr. Jay Chaudhary, that is senior counsel, assisted by Mr.
Arsham.
Arsham for that counsel for the applicant of the response number 8.
D. Saraf.
D. Saraf, the counsel for opposite party with petition.
Deeply obliged.
Obliged, Lordship.
Where this is the 31 is for? Okay.
My lord,
On the prayer of landed council for the petition list is better after 3 weeks.
my lord, actually, my lord, the admitted case, my lord, and
Where the FEDSL? That's why I wanted you to.
I inquired in the court, but not found, my lord. Day after tomorrow, my lord. Day after tomorrow, my lord.
After 2 weeks.
My lord.
In that case, next week in this. Next week.
Next week, any date, my lord. Any date, my lord. Next week.
Then in that case, heard Mr.
M. Hussain, my lord.
M. Hussain, land council for the, and also heard MS
S. Borwa.
S. Borwa, land council, land state council for
1 and 6.
1 and 6. None appears for the, then the council for the respondent number,
APDCL, my lord.
APDCL. Next paragraph. Considering that the APDCL is one of the main parties in
Yes.
the proceedings. Comma. Let this matter be listed after a week. The learned counsel for the petition shall inform the learned standing counsel for the APDCL.
My lord, date may be given. They are
Next
named
week. Any
Next
date
week.
next week.
18 or like 18.
Item 1 itu, itu boleh.
Yes, where is Mr. K. Gogoi? Reflected.
Yes, Lordship. We have filed our affidavit, Lordship.
No. Have you seen the order of 2009, 2024? Because this case diary,
Yes. I
in
have to
respect
inform
of
K.
the-
Gogoi then, Lordship.
Dalgaon PS case number 278 of 2000 is missing. Therefore, inquiry has been directed to be conducted, and on that, the KGO is supposed to obtain instruction.
Instruction, that instruction not received, Lordship.
None appears for the petitioners, none appears for the parties on call.
Lordship, I am referring for
Please
government
talk.
side, Lordship. K.
Yes.
Gogoi is a government advocate, Lordship. I am
So
also-
why?
Instruction, awaiting, Lordship. After
None
1
appears
week,
for the petitioner on call. MS
S. Borwa.
S. Barua, Learned State Council appears for
All respondents, Lordship.
all the respondents. List of next paragraph. On 20/09/2024, this court directed Mr. Kego, Learned State Council, to update as regards the inquiry to be conducted by the Additional Deputy Commissioner of Police within bracket crime Darang, Mangalgai, as the instruction was furnished to the effect that
Some time required, Lordship. Here we have received an instruction that the record is not available. So that, for that,
that has been recorded.
yes, Lordship. Some
in
more,
respect of the Dalgaon PS case number 278 of 2016. No. As the instruction were placed before the court to the effect that the case diary in respect of Dalgaon PS case number 278 of 2006, which was registered under section 448, 425, 379, A2C has been missing. And in that regard, an inquiry has been directed to be conducted. Mr. By fixing the date today, i.e. 09/12/2024. Mr. M.S.
As per
S. Barua, Learned State Council, submits that she is yet to receive the instruction yet to receive the update instruction as regards the inquiry to be conducted by the as regards the inquiry that is directed to be conducted by the additional superintendent of police crime within bracket close Darang Mangal Day. Therefore, he prays for further 2 weeks time to place the updated status of the matter. Considering its submissions, let this matter be the submissions. Let this matter be listed after 2 weeks, so as to enable MS.
4 weeks can be possible, Lordship.
Then 3 weeks. Place the updated status of the matter. List after 3 weeks.
Matters pertaining to Itanagar bench, bail hearing, bail application 65 of 24.
My lord, I'm appearing for a petitioner. So I have informed the other side also, my lord. Can it be fixed for Monday, my lord? Because my lord will be physically here on Monday, my lord, in Itanagar bench.
What is there? The charge sheet has been filed. What about the trial?
Trial comments, Your Lordship, Your Lordship, we have the instruction that the statement of the victims were also recorded, but we have not received the updated TCR.
Okay. What is this? I mean, how many witnesses have been?
The victim witnesses has just initiated, Your Lordship. The victim, two victims, Your Lordship.
So it's almost a regular process is on.
Yes, Your Lordship. PW's statements were recorded, but however, Your Lordship, the status we exactly don't know how many PW has been examined, Your Lordship.
You take the status on Monday.
Yes, Your Lordship.
Tuesday will fix it.
Yes, Your Lordship.
And there is a latest judgment of the Honorable Supreme Court. In such cases, if the charge sheet is filed, if the trial is going on, until so that the trial may take time, bail normally should not be granted.
Yes. My lord, can it be fixed on Monday, my lord?
Monday or Tuesday?
Monday, my lord.
Okay, no issue.
Deeply obliged.
Obliged. Where of Mr.
B. Nyarus, my lord.
B. Nyarus, learned counsel for the B. Nyarus, learned counsel for the applicant. Let this bail application be listed on 16/12/2024. Learned counsel, Mr. T. at the learned additional PP shall obtain updated status.
Your Lordship,
about with regards to the trial of the matter.
Okay, Your Lordship.
That will have a bearing.
Yes, Your Lord. I will get the status, Your Lordship.
MS N. Dangan, learned legal counsel is also present.
Obliged. Deeply.